Okay, Brian, sorry about that. I was having some technical difficulties. Thank you. Oh dear. Okay, are we about ready? So who's missing?
I think it's just us for this first case, right?
Okay, great. Mr. Young, would you please start the recording? Okay. Let's see. Good morning, ladies and gentlemen. The Board of Zoning Adjustments, September 10th, 2025, public hearing will please come to order. My name is Carl Blake, Vice Chair of the District of Columbia Board of Zoning Adjustment. Joining me today are board members Krishan Smith, representing National Capital Planning Commission, Zoning Commissioner Rob Miller, Commissioner Tammy Steedham, and Commissioner Dr. Joe Momora. Today's meeting and hearing agendas are available on the Office of Zoning's website. Please be advised that this proceeding is being recorded by a court reporter and is also webcast live via WebEx and YouTube Live. The video of the webcast will be available on the Office of Zoning's website after today's hearing. Accordingly, everybody who is listening on WebEx or by telephone will be muted during the hearing. If you experience difficulty accessing WebEx or with your telephone call-in, then please call our OZ hotline number at 202-727-5471 to receive WebEx login or call-in instructions. Today, we'll begin with our decision meeting session, then proceed with our public hearing session. Please be advised that we do not take any public testimony at our decision meeting session. Public testimony will be received during the public hearing session. However, only parties are allowed to testify in appeals. At the conclusion of a decision meeting session, the chair, in consultation with the Office of Zoning, will determine whether a full or summary order may be issued. A full order is required when the decision it contains is adverse to a party, including an affected ANC. If a full order may be needed, if the board's decision differs from the Office of Planning's recommendation, although the board favors the use of summary orders whenever possible, an applicant may not request the board to issue such an order. In today's hearing session, everyone who is listening on WebEx or by telephone will be muted during the hearing, and only persons who signed up to participate or testify will be unmuted at the appropriate time. Please state your name and home address before providing oral testimony or your presentation. Oral presentation should be limited to a summary of your most important points. When you're finished speaking, please mute your audio so that your microphone is no longer picking up sound or background noise. Once again, if you experience difficulty accessing WebEx or with your telephone call-in, or if you have forgotten to sign in up to 24 hours prior to the meeting, then please call our OZ hotline number at 202-727-5471 to sign up to testify and to receive WebEx login instructions. All persons planning to testify either in favor or in opposition should have signed up in advance. They will be called by name to testify. By signing up to testify, all participants completed the oath or affirmation as required by Subtitle Y, Section 408.7. Requests to enter evidence at the time of an online virtual hearing, such as written testimony or additional supporting documents other than live video, may not be presented as part of testimony, may be allowed pursuant to Y, Subtitle Y, Section 103.13. The order of procedure for special exceptions and variances are pursuant to Subtitle Y, Section 409. The procedure for appeals are pursuant to Subtitle Y, Section 507. And time constraints will be maintained pursuant to Subtitle Y, Sections 408.2 and 408.3. At the conclusion of each case, an individual who is unable to testify because of technical issues may file a request to leave the record open to file a written version of the planned testimony to the record within 24 hours following the conclusion of the public testimony in the hearing. If additional written testimony is accepted, then parties will be allowed a reasonable time to respond as determined by the board. The board will then make its decision in its next meeting, but no later than 48 hours after the hearing. At the conclusion of the hearing, the board may request additional specific information to complete the record. The board and staff will specify at the end of the hearing exactly what's expected and the date when the persons must submit the evidence to the Office of Zoning. No other information shall be accepted by the board. Once again, after the board adjourns the hearing, the Office of Zoning, in consultation with the chair, will determine whether a full or summary order may be issued. A full order is required when the decision contains adverse to a party, including an affected ANC. An order may also be needed if the board's decision differs from the Office of Planning's recommendation. Although the board favors use of summary orders when possible, an applicant may not request the board to issue such an order. Finally, the District of Columbia Administrative Procedure Act requires that the board public hearing on each case held in the open before the public. However, pursuant to sections 405B and 406 of that act, the board may, consistent with its rules of procedure and the act, enter into a closed meeting for purposes of seeking legal counsel on a case pursuant to DC Official Code Section 2-575B4 and or deliberating on a case pursuant to DC Official Code Section 2-575B13, but only after providing the necessary and public notice and in case of emergency closed meeting after taking a roll call vote. Madam Secretary, do you have any preliminary matters?
Good morning, Mr. Vice Chair and members of the board. Welcome back. Regarding the schedule today, application number 21209 of 304-306 and 308 K Street LLC has been postponed to November 5th, 2025. Also, the chairman has reviewed and granted waivers to allow late filings into the applicable case record pursuant to Subtitle Y, Section 206.7 and Section 103.13. Any other late filings during the course of today's live hearing should be presented before the board by the applicant, parties, or witnesses after the case is called. And any other preliminary matters will be noted when the case is called.
Okay, thank you very much. Madam Secretary, would you please call our first meeting issue case?
The first item in the board's meeting session is application number 21298 of Justin Riordan and Zach Bache. As amended, this is a self-certified application pursuant to Subtitle X, Section 1002 for area variances, from Subtitle C, Section 302.1 to allow a subdivision to create new record lots not meeting minimum requirements for lot width or side yard, from Subtitle D, 208.2 to allow side yards of less than 8 feet, Subtitle D, Section 202.1 to allow a lot width less than 50 feet, and Subtitle D, 5003.1 to allow an accessory structure with building area greater than 450 square feet or 30% of the rear yard. This is for the subdivision of 2 existing record lots to create 2 new record lots with an existing detached dwelling on one new lot and a new 2-story detached principal dwelling on the other new lot. This project is located in the R1B zone at 1306 Girard Street Northeast, square 3958, lots 8 and 9. The public hearing for this case was completed on July 30th, 2025. The board voted to approve the application except for the side lot variance relief for the new lot B. Participating in the hearing and vote were Chairman Hill, Vice Chair Blake, Board Member Smith, and Commissioner Stidham. And then on August 7th, the applicant withdrew the side lot variance relief for Lot B and also submitted a request to open the record to allow and revise plans, which is before the board today.
Thank you. So as the secretary indicated, this board heard this case on July 30th. And essentially the board approved the application except for this side yard issue on Lot B. The board didn't believe that the applicant met the standard for the area variance for the side yard relief on that lot and thought it more of a design issue than a necessity. The applicant is now requesting the board to reopen the record to submit the supplemental materials with updated architectural plans and elevations showing a proposed structure on Lot B with compliant side yards. So the applicant, as Secretary pointed out, is also seeking to withdraw the request for an area variance from D section, subtitle D section 28.2 for Lot B. So the board has the authority to reopen the record if the applicant demonstrates good cause and a lack of prejudice to any party. I believe that the applicant has demonstrated good cause, and I'm prepared to grant the request to reopen the record for these submissions if there are no objections from other members of the board. Okay, hearing no objection, we will reopen the record for those submissions. Now, Chapter Y, section 602.7 requires that we distribute the supplemental materials to other parties in the case and allow 7 days for response. While there were some letters of opposition and support, A and C 5B is the only other party. So we're going to have to provide them with the supplemental materials before we can actually take action. So we'll have to set a decision date to vote on the revised application. Madam Secretary, can you help me a little bit with that date? Can we do that next week?
You could set it for a decision next week if you wanted to set a response period of 6 days. You could have the ANC respond by next Tuesday. That is within the board's purview. So, but it's up to the board what you'd like to do.
Well, I mean, the ANC was in support of the project, and I think the board will be comfortable getting the information out of the ANC right away. And if we can reduce the response period to 6 days, I think it would be great to take it up in our next session. Mr. Smith, would you be comfortable with that?
Yes, I'm comfortable with that.
Okay, Commissioner Steele?
I'm also comfortable with that.
Okay. Madam Secretary, do we need to take a vote or have we sufficiently satisfied this?
You don't need to take a vote to reopen the record.
Okay, so so we'll close this for now. The only information that the record is open for is this submission and the comments from the ANC if they have any, but nothing else will be permitted into the record besides that. And we will take action on this at the decision meeting next session. Okay, can we now go into the next, what you call the next case?
Tammy, that was your last case for today?
Yep, that was it. You guys have a great day.
I'll see you. Sorry about that. Thank you. Bye.
Take
No
care.
worries. Bye.
Okay.
The next item on the board's meetings agenda is application number 21119A of Vikramaditya Raylan and Bina Raylan. This is a request pursuant to subtitle Y, section 700.2 for reconsideration of an order issued on July 29th, 2025 that approved special exceptions under subtitle U, section 421 to allow a new residential development, and under subtitle C, section 714.3 from the parking screening requirements of subtitle C, section 714.2. This was for the creation of 2 additional dwelling units in an existing 4-unit apartment house, the 3rd story and 3-story rear additions to the existing 2-story semi-detached building. It's located in the RA1 zone at 2232 40th Street Northwest, square 1317, lot 15. Again, the order approving the application was issued on July 29th, 2025, and participating in the original proceedings were Chairman Hill, Vice Chair Blake, Board Member Smith, and Dr. Imamura. And on August 8th, the party in opposition, Marla Lethwich, submitted a request to extend the 10-day deadline to file a motion for reconsideration. And on August 19th, Ms. Lethwich filed a motion for reconsideration.
Great, thank you, Madam Secretary. This is a little bit of a complicated matter, but we should be able to go through it pretty quickly, actually. So the applicant has filed a motion for reconsideration for the order. The order, as the Secretary pointed out, was issued on July 29th, making the 10-day deadline for a timely motion for reconsideration August 8th. So the party in opposition submitted a request on August 8th, though, asking the board to extend the 10-day deadline. And the party in opposition then filed a motion for reconsideration on August 19th. So before moving into evaluating the merits of a motion to reconsider, we need to first address the request to extend the filing deadline. Now, Section Y, Subtitle Y, Section 101.9 authorizes the board to extend the deadline if it finds good cause and if the waiver will not prejudice the rights of any party. The party in opposition argues that they didn't, as it relates to good cause, the party in opposition argues that they were not served a copy of the order. Now, this could be considered good cause, but there's information in the record to the contrary. To me, though, the bigger picture issue is the prejudice, as the applicant has been already given the opportunity, given the green light essentially to pull permits and commence work. So in that instance, because of the prejudice and the questionable good cause, I don't believe that the party in opposition has met the standard set out in Subtitle Y, Section 101.9, having not sufficiently demonstrated good cause or lack of prejudice. Mr. Smith, what are your thoughts?
I completely agree with everything you stated. The reasons raised by the party in opposition, again, deal with noticing. And that was something that we discussed at length at the hearing. And the applicant was noticed, properly noticed, and had the ability to speak on the issues that she raised at the hearing last year. Again, the party in opposition is continuing to beat the same drum of she wasn't properly noticed, and I think we fully aired that out at the hearing last year. So I would not be in favor of opening the record, reopening the record for this and reconsider.
And you would not feel comfortable with the extension either?
No.
Okay.
She hasn't shown proper cause.
Okay, thank you. Dr. Imamura?
Thank you, Mr. Vice Chairman. I'm in agreement with you and Board Member Smith that specific to Section 101.9, that she hasn't shown good cause here. To Board Member Smith's comment that the issue of the notice, I think there's sufficient evidence to the contrary in the record there. So I'm not in favor of the extension here, nor am I in favor of reconsideration.
Okay. Well, therefore, having deliberated this matter, I'm going to make a motion to deny the request to extend the filing deadline and to dismiss the motion for reconsideration and ask for a second, Mr. Smith.
Second.
The motion has been made and seconded. Madam Secretary, would you please conduct a roll call vote?
Please respond to the Vice Chair's motion to deny the request to extend the filing deadline and dismiss the motion for reconsideration. Vice Chair Blake.
Yes, to deny and dismiss.
Board Member Smith.
Yes.
Dr. Imamura.
To deny and dismiss.
Staff would record the vote as 3-0 to 2 to deny the request to extend and dismiss the motion for reconsideration on the motion made by Vice Chair Blake and seconded by Board Member Smith. with Chairman Hill not participating.
Thank you very much. Dr. Lamora, that is your only case today. Is that, am I correct?
That's correct.
All right. Thank you very much. We'll see you.
Thank you.
All right. Madam Secretary, could you call our next case? Hello, Vice Chair Miller. All right. Madam Secretary, thank you.
Next on the board's meeting session is an expedited review application number 21340 of Shannon and Andrew McMahon. This is a self-certified application pursuant to Subtitle X, Section 901.2 for a special exception under Subtitle D, Section 5201 for the side yard requirements for an accessory building under Subtitle D, Section 5005.1. This is for a rear addition to an existing two-story detached principal dwelling with a one-story accessory building that would be located within the required side yard. It is located in the R1B zone at 3048 Oliver Street Northwest, square 2315, lot 811.
The applicant here proposed a rear addition, 1 or 2 stories, and an existing attached principal dwelling unit with accessory building that meets the matter right development standards of the zone. But because with the addition of the principal structure, the existing accessory building will be located in the required side yard. Having reviewed this, I think the record is full, and I believe this application is appropriate for the expedited review. I agree with the Office of Planning's analysis that the applicant has met the burden of proof to be granted the requested relief, as the project shouldn't result in an undue adverse impact on neighboring properties. The garage will be in the same place and maintain the same dimensions. As such, given the addition of the principal building, there'll be no change to light, airflow, or privacy or use of enjoyment of neighboring properties. The garage is similar to the adjacent neighbor's garage and the other garages on the street, so maintaining its location on the property would allow the applicant to continue having on-site parking and not to take up any parking space on the street. So I see it overall as a positive. We give great weight to the Office of Planning's recommendation for approval, but also give great weight to the written report of ANC 34G, which is in support, states no issues or concerns. Also, in an email from the Office of Planning, DDOT stated they have no objections to proposed relief. And I would also note that there are several letters of support from neighboring properties, including the abutting neighbors to the east, west, and south. So I'll be voting in support of the application. Mr. Smith, do you have anything you'd like to add?
I have nothing to add. I agree with your analysis of this particular case, and will vote in support.
Thank you, Vice Chair Miller.
Yes, Vice Chair Blake, that was very thorough analysis, and I agree with it. Thank you.
Thank you. Madam Secretary, having deliberated, I make a motion to, Madam Secretary. Having deliberated, I'd like to make a motion to approve application number 21340 as captioned and read by the Secretary, and ask for a second, Mr. Smith.
Second.
Motion's been made and seconded. Madam Secretary, would you please conduct a roll call vote?
Please respond to Vice Chair's motion to approve the application. Vice Chair Blake,
Yes.
Board Member Smith,
Yes.
and Commissioner Miller.
Yes,
Staff will refer the vote as 3-0 to 2 to approve application number 21340 on the motion made by Vice Chair Blake and seconded by Board Member Smith, and Chairman Hill not present or participating.
Thank you very much, Madam Secretary. Would you please call our final meeting case?
Next is application number 20992A of National Presbyterian Church Incorporated. This is a request pursuant to Subtitle Y, Section 703 for a modification without hearing of the special exception approved in application number 20992 to allow changes to the location of the Child Development Center and the pickup drop-off area. The project is located in the R1B zone at 4101 Nebraska Avenue West, square 1724, lot 805.
Okay, I believe that, thank you very much. The request is on the modification without hearing calendar. And I do think it's appropriate for the calendar, as the facts can be, that the implications can be readily understood without a hearing. the original order, in the original order, the applicant intended to convert the lower levels of an existing agency building into a child development center for up to 16 children and 4 staff members. Now they plan to relocate the child development center to the second floor of a church building in a newly constructed space. So they're seeking BZA's approval to modify the plans approved in that order to do that. They're also seeking to modify the pickup and drop off location, which will be further down in the campus from where it initially was with the agency building to the actual church entrance. The approved pickup and drop off site plan layout were presented in pages 2 and 3 of Exhibit 2, and the proposed pickup drop off plans are also presented in pages 4 and 5 of that same exhibit. Through the original order, the applicant was granted approval for a pickup drop off area located behind the on-site agency building. With the subject modification request, the applicant now proposes to relocate the pickup drop off area behind the National Presbyterian Church building. The pickup and drop off area would continue to be accessed through Van Ness Street, and the area would be relocated from behind the agency building to the entrance of the church. The access pickup area would actually continue to be on Van Ness Street. But the interesting thing about it is that because it's further down, it would actually improve the queuing coming into the campus. So to continue with the conditions pretty much remain the same. There's no change in number of students or faculty. It looks like the new pickup and drop off area, like I said, will actually reduce the potential congestion on Van Ness, although it probably wouldn't be that much from so few students. But I agree with the Office of Planning's analysis, and I give great weight to his recommendation to grant the requested modification. According to the Office of Planning, DDOT has reviewed the subject application and has indicated that there's no objection as presented. Interestingly, ANC 3A had took no position in this, but they were in support of the previous application. So I suspect there's nothing to give great weight to from the ANC in this matter, but they are aware of it and they are not in opposition. So I'll be voting in favor of this application. Mr. Smith?
I have nothing to add. I agree with your analysis as well as the Office of Planning's analysis on this particular case. And I will vote in support.
Vice Chair. Or
Thank you, Vice Chair Blake. Yes, I agree with both of you, and prepared to support this application by National Presbyterian Church.
thank you. Okay, having deliberated, I'd like to make a motion to approve the modification, to grant the modification. And ask for a second, Mr. Smith.
Second.
Madam Chair, Madam Secretary, having completed deliberations and had a second, would you please call a roll call vote?
Please respond to Vice Chair's motion to approve the modification. Vice Chair Blake?
Yes.
Board Member Smith?
Yes.
Commissioner Miller?
Yes.
Staff will record the vote as 3-0 to 2 to approve application number 20992A. On the motion made by Vice Chair Blake and seconded by Board Member Smith, Chairman Hellman has it ordered.
Excellent. Board members, I'd like to take a 15-minute break before we begin our public hearing sessions and cover it. And then after that, we'll go through a few of the cases and take a brief break after that. Okay? So a 15-minute break. I'll see you back shortly. Secretary, would you please call in our first meeting, our first hearing case?
Yes, the board is back from a quick break and is now entering its hearing session. The first case is application number 21327 of Yipsira Gata and Mulework, Kenya. As amended, this is an application pursuant to Subtitle X, Section 901.2 for special exceptions under Subtitle U, Section 251.1B3 to allow an expanded child development home for up to 12 children. And under Subtitle U, Section 251.6B to allow modification of Subtitle U, Section 251.3F to allow operation related to a home occupation outside a structure. This is for the increase in the number of children from 9 to 12 at an expanded child development home in a detached principal dwelling. It's located in the R1B zone at 4433 19th Place Northeast, square 4186, lot 35.
Excellent. Thank you very much. Could the applicant please introduce yourself for the record and anyone who will be joining you today?
My name is Mulorka Kenya. My address is 4433 19th Place. I'm home child care provider. We are today presented to extend our daycare for 9 to 12.
Okay, thank you, Ms. Kenya. Will anybody be joining you today as well?
Miss Yabsra, she's joined, but she's in work. We have observation, fikr observation. She have one of us we have to attend. She is there. She will be for a movement for hearing because she's with OC on the observation part.
Okay, all right, thank you very much.
Miss
Are
Yabsra,
you-
please come here. Just
What-
give me a second.
Okay. No problem.
Hello.
Hello, how are you? Thank
Hi,
you very
good
much.
How are you?
Okay.
Sorry, I'm working right now. That's why, I have an observation, so I cannot go to meet you
Okay.
guys. I'm sorry about that.
Okay, thank you very much.
Thank you.
Mhm. Ms. Kenya, do you have a presentation that you'd like to make?
Yes.
Okay, is it, Mr. Young, do you have that slide deck? Okay. So would you please give us you have 15 minutes to tell us a little about your project and what you're trying to do, and welcome back. We remember you from the last time. Please give us, let us know exactly what you're doing and how your project meets the criteria for approval. We'll put 15 minutes on the clock so we can keep track of where we are, and you can be in whenever you like.
Okay. Again, my name is Mulork and my partner is Yabsra Gada. It is this family-owned business. This is our second program. We need to extend, child development to 12 because of we have a lot waiting list. We are working with Children's Hospital and Washington Hospital. We are the nearest. We are provide for them for non-traditional or the evening programs. That's why we need to extend our program and the day program to the same thing around our area. We need more space for early childhood and we are professional. Please go to the second, the other. Okay. Again, I want to introduce myself. It is I'm in family child care. It is this one we started 2016 this program, but this is the second part. Started 2023 and 4433 19th place. We are currently full capacity of 9 children, and we are high quality rent and early Head Start program. We are NFC credential in progress, and our sister branch it is located in 5357 Gay Street, and we serve most of low income client based on the neighborhood area, and we are working with child subsidy program and Queen. Next page. Why did we start this business? because we believe all young family deserve both accessible and high quality child service. And our experience, it's 10-year experience at Gap Community Child Care as head teacher, and 2016 owning my own home extended child care, and since right now, and the second one is almost 2 years too. My personal experience and my sister experience, it is she's a pharmacist, I am early childhood educator, I have my master, she have her in pharmacy bachelor degree, and she have CDA. We are taking different kind of class, and we serve communities and cultural places, same like churches, same like most Ethiopian communities, by teach the children's language and culture, and wherever when we have community service, we are serving in different place. Next page, please. Our child care, it was I say it about our credential, but our child care, it is nature based, and we believe children's by play they learn, and we use creative curriculum, and we help different kind of pupils, and same like low incomes by provide resource, and wherever they need it is we are offering same like different kind of classes and stuff, as we work with the families too, not only we work with the children's. Service we provide, our program is 24-hour daycare service, age 0 to 12, working with Children's Hospital and Washington Hospital, and collaborate with finance and programs here, provide clients with DC Child Subsidized program, and as well as private people. And our program, again, multicultural education, multi-different background, problems, habits, and health, home cooking. We are providing healthy home foods, and we use creative curriculum and DC core. Next. Why we extended this, you see the picture, that one is the other program with those blue one, that's the light blue one. We say this is the second year, but this year we have 5 children from to start school. That's why we see our domain that is high. That's why we extended and provide for the community high quality child care, and the same times about the staff to create a work. We will hire this programs extended from 12. We will hire more staffs, and we create job opportunity. And it is a parent, they have siblings, when they need, they bring their children in, when they don't have a school, when we have enough space, we'll accept to them when anytime when they need. Next page. Neighborhood need, high family present, one in 3 household included family with young children, large youth population, 1 in 4 residents are youth age 0 to 18, children's service shorting, limited access to early child education and aftercare program. Nearby area like Michigan Park face similar gaps, and opportunity for impact, strong need to quality affordable children's in the community. Next. North Michigan Park is our Brookland or Fort Tatten, Northeast DC. For many families, essential this child attend below price elementary, just minute away, rehab and aftercare option we heard. And the mother community members understand creative need accessible high child care. That's why we established family child care to fill the gap and support family to neighborhood. Next, please.
Ms. Kania.
Yes, sir.
I'm sorry if I'm. Could you pronounce your last name again? I'm sorry.
Kenya, you're right.
Kenya. Thank you. We have the PowerPoint presentation from you within the record. I would note, I'm looking at the other slides, these later slides. We note that the ANC is in support of the application, and I think and you have a lovely program. I think we probably have some additional questions that we want to ask.
Sure.
We could probably stop the presentation here if any other board members have some additional questions.
Okay.
Okay, Mr. Smith, you have a question.
Yes, I think I just have one question. It's about the pickup and drop off arrangement. How is that being handled now? Is that occurring within the street or within the alley?
We have both sides. We have 3 gates and we have on alley side, but we use it in the front because our street is too big and we have a lot parking slot and we have driveway to 3 people, so they will park in the driveway.
They park in the driveway.
Yes.
So they rotate in and out. You have a driveway?
Yes.
It's in the rear?
Yes, I have two car driveway in the alley, in the back
In
alley.
the alley. Okay, so all pickup and drop off occurs in that driveway within the alley.
Yes, sir.
Okay, and what if there is 2 cars currently parked in the driveway now? So what happens with that 3rd car?
Third car?
If the driveway is taken up with 2 cars and there are other vehicles waiting to pick up another child, say it's a 3rd or 4th car, where are they waiting? In the street?
To be honest, in front of my house, I have a slot 5 cars. It's on my property. That's why we don't have parking problem.
Okay.
Yeah.
Okay. Yeah, I just wanted to make sure that they weren't queuing in the alley. So you've answered my question.
I have a question for you with regard to the layout. Are all of the activities on the first level? All the childcare takes place on the first level of the building? Is that right?
Yeah, that is all the activity will be the first of the label because the house, it is a split house, all the living room.
Okay. And you also have an outdoor play area. I assume that's what the modification, the waiver is for the outdoor play area?
Yes.
Right?
Yes.
Okay.
Yeah.
Okay. Okay. Thank you very much. Vice Chair Miller, do you have any questions?
Thank you, Vice Chair Blake. No, I don't think I have any questions. This is very similar to a case by this applicant for their sister child development centers, as was noted by the applicant on 5357 Gay Street Northeast, which we approved the special exception there for a similar increase. So I have no question.
Thank you very much.
With that, thank you very much for your presentation. I'm going to ask the Office of Planning for their report now, please.
Good morning, Vice Chair, members of the board. This is Joshua Mitchell with OP. We've analyzed the application and are willing to rest on our analysis provided in OP's report, and we're available for any questions. Thank you.
Okay. Mr. Mitchell, I have a question for you. You state you've provided relief from let's see, from something that the applicant's actually not asking for. can you elaborate on that?
Could
Relief that
you
actually?
could you explain which one you're referring to? Is it the maximum square foot allowed or?
Yes. Yeah.
So per the applicant's burden of proof, it was submitted a little bit after the fact, but it stated that they were currently using 500 square feet right now, a square feet of usage for the use, and so per the regulations, the the maximum would be 250 square feet. So that's why we stated it as right now they're using 500, 250 square feet is the max, and then they're just proposing to bring it into compliance for the 500 square feet as proposed.
Okay, I think the interpretation we've had is a little bit different. I do not think that we read it such that the maximum size provision of youth 251.3B is actually applying to to daycare uses. The maximum size provisions basically exclude the daytime care uses, and the 35 minimum area dedicated of 35 square feet per individual is the level that we use for that measure. So I think that is the way we've interpreted it. Mr. Smith, if you want to add to that, that'd be fine.
Yeah, so I'll add to it. Let's see. The particular provision, Mr. Mitchum, that you're referring to, or you've requested the applicant get a some relief from, is 251.3B. So it says for except for lodging and as provided in subtitle U, section 251.1B and 251.1F. So in essence, uses within those two subtitles are excluded from this 250 square foot requirement. So this will point to, or the regulations for a home, this particular type of use, child development home, will point to 251.1B, which are the development standards for an expanded child development home. So I believe probably that particular type of relief that you're referencing would not be needed for a child development home. They would just need to meet the standards in 251.1B. And under 3, they can get a special exception. They just have to maintain 35 square feet per child. So 35 times 12, whatever that is, 420 square feet.
Yeah, per our calculations, they would meet the as stated in part, they would meet that requirement. Yeah.
Okay, so probably that special exception isn't needed. So we can move forward with the 2 that's requested by the applicant.
Would you like a supplemental report at any point or to rectify that or?
No, I don't think so.
The other thing, Mr. Mitchell, is you did not actually talk about the waiver that the applicant is requesting for the outdoor equipment. That would be U 251.3F. Can you speak to that?
Sorry, let me just pull up my notes real quick. Let's see. 253F. That may have been an omission. Let me, if you don't mind, I would have to double check our my past notes on that. Let me see.
Okay, if you need a minute to check on it, that's
Yeah,
fine. We have
need to check
quite
that.
a bit of public testimony.
Sure.
So you have a few minutes if you want to kind of look at your notes and come back at us with that response
Sure.
and evaluation of that. Okay?
Thank you.
All right, thank you. All right, so let's see. Is there anyone from the I should know that. No, there's not. Mr. Young, are there any people willing that interested in testifying?
Yes, we do.
Okay. Would you please admit them in, say, 3 at a time?
Yep.
Thank you.
So the first three are Mahalet Drar, Camilla Williams, and Elias Sekecho.
Okay, thank you. We appreciate you having the public commentary and testimony. We're gonna have 3 minutes for everyone to give their testimony individually. Please make sure you state your name and home address before providing any oral testimony in your presentation. Now, I remind you, please try to keep your presentations limited to it's your summary of your most important points. So, we'll have the first person. It's, Camilla Williams.
Good morning, everyone.
Morning. Is your picture working? Is your
Oh,
screen working?
can you see me?
No, I can't. Oh, I can see you now.
Okay.
Would you please introduce yourself and give us your address for the record? And you have 3 minutes to give your testimony. Mr. Young, please put 3 minutes on the clock and you begin whenever you like.
Okay. My name is Camilla Williams. My home address is 1632 F Street Northeast, and I am a working parent, full-time student in this community. I'm here to express my strong support for the proposal to extend daycare hours for families like mine who work non-traditional and extended schedules. This initiative will benefit families in our community, especially those in working healthcare, hospitality, emergency services, and other that demands long and irregular hours. It would be also empowering parents to pursue career growth, education, and second jobs of all, which ultimately strengthens our household and our neighborhoods. Thank you for your consideration to this essential step in supporting working families. Thank you.
Thank you very much for your testimony. Who's next? Miss Shink, I can't, Elias?
Yes, good morning.
Good. Would you please introduce yourself for the record and give us your name and address? And as a member of the public, you have 3 minutes to give us your testimony. Mr. Young, please put 3 minutes on the clock, and you can begin whenever you like.
All right. Sure. Good morning. My name is again Elias Sekecho. My address is 5210 3rd Street, Northeast Washington, D.C. I've been knowing Ms. Muluwork and Yabstra Gadaslu family members, and I'm in strong support with extending their child development center. As stated by the founder of this child care development center, I know how helpful, great opportunity for creating a job for our city, as well as supporting a working family. So extending this child care development center would support the families that work late nights, morning, early morning, as well as it would create an opportunity for the DC residents for creating a job opportunity, helping, supporting. So this, I've been knowing Ms. Woolwork not only as providing a child care development center just for earning incomes, also supporting the community with awareness education through a lot of different areas of day-to-day life. So creating an opportunity for Miss Woolwork and as well as Yabstra Gada. This will support our city, this will support our community. This will also encourage others to self-reliance, self-independence, to creating a job and improving day-to-day life. So I'm in favor here. That you guys would consider supporting and helping a growing community try to build and create the best living environment in our city. Thank you so much, and that's all I have for you.
Thank you very much for your testimony. Does anyone have any questions? Okay, we'll ask the third person to speak now. I cannot remember your name, Miss Malha. I can't. But yes,
Yes,
thank
this
you very
is
much. Would you,
Mahalet.
Mahalet, would you please state your name and the address for providing oral testimony? You have 3 minutes. And Mr. Young, would you please start the clock? And you can begin whenever you like.
Good morning. My name is Mahalet Drar. My address is 3418 It's Street, Northeast Washington, D.C. I know Miss Mulu and her partner for a long time, and one of my children attended Child Development Center for about 3 years, and it was a very loving and caring home for my child. She learned a lot from the center, and she loved. Until today, she called them auntie because of the love and the care they provided. So this expansion will give opportunity for working parents like me to have an option. So our kid or children will have more place to stay. And because of the love and the diverse of the providers, they will learn more. And I hope you approve this expansion, and I support.
Okay, thank you very much
Thank
for your
you.
thank you very much for your testimony. Does anyone from board have any questions there? Okay, so Mr. Young, would you please call in 3 others?
Yes, the next 3 are Shaquan Smoot, Mestawet Dejeen, and Cynthia Davis.
All right, thank you. Again, let's see, we have our first panel. We're going to limit our public commentary to 3 minutes. And if you please state your name and address before you begin your oral testimony, we appreciate it. We'll first call up Ms. Smoot. Ms. Smoot, go ahead, Ms. Smoot. Would you please give us your name and address and provide us with your testimony? You have 3 minutes. Thank you. Begin whenever you like. Ms. Smoot? You're muted, I believe. I see your face, but you're muted. Okay, I see Ms. Davis there. Ms. Davis, would you like to give me your testimony? You have 3 minutes.
Yes, can you see me on camera?
I can see you and I can hear you.
Okay, good.
Mr. Young, would you please start the clock? You have 3 minutes. Please provide us with your testimony. Of course, provide us first with your name and your home address. Thank you.
Oh, I guess Miss Smoot is there. I think I heard her in the background.
Okay, we'll come back to her as soon as you go ahead and I'll come back to Ms.
Okay.
Smith. She was having technical difficulties.
Okay, great. Hello, everyone, and thank you so much today to allow me to provide my testimony in support of BZA case 21327. My name is Cynthia Davis, and I'm the founder and CEO of Kings and Queens Child Care Center, located at 4831 9th Street Northwest, Washington, D.C. 20011. Um, I'm also the founder and I'm also the executive director of the DC Family Child Care Association, which is located at 6100 Chilham Place Northeast, Suite 204, Washington, D.C. 20011. I'm here in support of Mulu Work and Yepsira Geta with expansion. I'm also in a location that that supports doctors, and I'm also a 23-hour program as well. Since since the pandemic, we all three of us has really stayed open during that time and has continued to support essential workers because we're essential workers ourselves, and we wanted to continue that support by expanding our programs. So just like the Mulu Works program on Gay Street, I was there to testify to in support of adding more children and families because we are proximity experts. We live in the community. We know exactly what's going on with the community, and we provide resources and as well as childcare for the community. So therefore, I'm totally in support of Mulu Works and at Yesera Geta expansion to 12 children. Thank you so much for allowing me to speak.
Thank you very much for your testimony. Thank you for what you're doing in the community as well. Ms. Smoot, can you hear me? Ms. Smoot, can you hear me? I see you there. Mr. Young, is she mute or something like that? I don't think so. All right.
Doesn't look like she's muted.
Okay. Ms. Smoot, can you hear us?
I
Perhaps
don't
you
think
want
so.
to perhaps you could call in on our helpline. What is the let's see, we can call in the helpline. Let's see here. Mr. Young, could you pop the larger number up there so I can see it?
It's 202-727-5471.
Okay. Ms. Smoot, did you hear that telephone number? If
It
you're
doesn't
able to
look like
call us
she
back at
can, it doesn't
202.
seem like she can hear us because she's not having any reaction.
I agree. I agree.
We can have staff reach out to her.
Can you have
Yes.
staff reach out to? Who said that? Who said
I'm not
that?
sure.
Okay. Could you have staff reach out to her and then we'll try to get her on before we have another section of folks after this, so we'll try to get on after that. Okay. All right. So we'll go to our next person who is Ms. Dinjan. Is that right?
Yes, Mr. Jenny.
Mr. Janae, would you please state your name and address, and you have 3 minutes to provide us with your presentation. Please state your name and address before beginning, and you have, please bring maybe like, Mr. Young, start the clock.
Okay, my name is Mr. Dejani. I live in 1703 Bunker Hill Road, Northeast Washington, D.C. 20017. So I'm here to support Mudwork and Yabsrageda. So I'm in Child Development Learning Center. This is such a big milestone and true blessing for community. They are not only a great provider, but also a teacher, a mentor, and a supporter for children and family. Amin Child Development Learning Center is more just a daycare. It's a place where children feel safe, learn, and grow with confidence. Their dedication, love, and passion for helping children shine through in everything you do. By opening this second center, you guys are giving more family the chance to experience quality care and early learning. This new step show your hard work and commitment, and I'm so proud of you guys. You are making a lasting difference in children's life in the community. Thank you.
Okay, thank you very much for your presentation. Again, thank you for what you're doing to help us as well in the community. Does the board have any questions for these folks? Okay. Mr. Young, you can dismiss these witnesses and bring in the next, and we'll try to get Ms. Smoot back on at some point, I hope. Young, can you call the next folks?
Yeah, we had 2 more signed up, but it doesn't look like they're on anymore.
Okay, so is that all that we have?
That is all.
Okay, can we get Miss Smoot back at all? Have you tried to see if her screen is still there?
Yeah, I think that staff talked to her and she's gonna be calling in by phone, so I'll let you know when I see her.
Okay, great, thank you. Well, we don't have any more testimony from the public other than that, so we'll wait for that. Perhaps we can revisit the Office of Planning now.
Hello again. That is, we were looking in the record and we don't seem to have seen the request for the waiver in the record. That seems to be why we didn't mention it in the report.
Mr.
I'm
Mitchum,
just-
it's in the referral letter from the ZA, the most recent version of the 3. It's in the third one.
The third one.
And it's also provided commentary in the supplemental report from the applicant. Lastly, it's been one of the most recent exhibits.
Let me double check here. Vice Chair, could you repeat what was the exhibit number that you had mentioned for the ZA's report? Was it exhibit 22? Okay, let me see. So U251.3F, which would be the operations of a home business must be internal to the building. Let's see.
So with regard to the play yard, it's the similar relief we gave in the last
Right.
application.
Yeah, if you would like us to look into it further, we can probably do this in a supplemental, but that seems to have come after the bulk of our analysis here. But yeah, we can add this into a supplemental report, but it wouldn't change our ultimate recommendation of approval for the application as presented.
I think that we have the ability to make 2 modifications of those provisions in 251.1 through 251.4. And this is the only one that we're seeking at this point. So I think the board, now I guess I can say certainly that the other members have any questions. I have any problem providing that modification. I don't think it would have an adverse impact. It would fit in with it is part of the recommendation and the request from the ZA and the referral letter. Mr. Smith, do you have any comment on that?
No, well, my comment is I'm assuming this is for the playground, so I don't have any comment on the requested relief from 251.3F. So that Ms. Kenya.
Yes, you have a comment, Ms. Haney?
Yes, I send the waiver to the DOB. They send it to me, and I attach with my application. And I don't know who's her name. She received it. Zone of planning.
Yeah. So we acknowledge that. That relief was requested. It just wasn't an analysis done by the Office of Planning for the relief that you requested.
Okay.
I'm Chairman Blake. I'm comfortable with proceeding with including the relief with 251.3F. And Mr. Meacham, I don't think that we need a supplemental report for this.
Okay. Also, Office of
I would
Planning
agree.
would add that we would support the waiver if it was necessary. It wouldn't change the findings of our report.
Perfect. Thank you very much. Do we now have Miss on the line? I see someone on the telephone. Ms. Smoot, is that you on the telephone? If so, can you unmute yourself?
Yes, this is Shaquan Smoot.
Welcome. Thank you very much. It's nice to finally get you on the line. Would you please provide your testimony? You have please state your name and home address, and you have 3 minutes to provide your testimony. Mr. Young, would you please begin the clock? And Ms. Smoot, would you begin your testimony whenever you'd like?
All right. My name is Shaquan Smoot. My address is 2505 12th Place Southeast. I've been with Mona Lou for over 10 years. She was very helpful for me and my children. I just had a newborn baby. She had my baby. Now he's 4 months. She was very helpful. She also extended her program for my other kids, picking them up from school, helping them with their homework. I mean, she is truly amazing. My kids also know how to speak 2 different languages, and they're doing well in school. So I think that's exactly what she needs to extend.
Okay. Thank you very much for your very warm testimony. Ms. Young, I think we can dismiss the testifier. And I'd like to say this has been a very warming conversation. Ms. Kenny, you clearly are doing some really good work that people are very excited about. I'm really excited about it. I appreciate what you're doing. Is there any, the board members have any questions for the applicant?
No.
Vice Chair Miller?
No, I have no questions, and I concur with your comments about the good work of the applicant. And thank all the witnesses who we saw, many of whom we saw in June on the sister child development facility. So good to see you all.
Okay. Thank you very much. And thank you very much, Kenny. We'll talk to you very soon. Hopefully we resolve this very quickly. Thank you. Mr. Young, would you close the hearing and dismiss the witnesses? And we'll move on to deliberations. Thank you. I'm in support of this application. I believe the applicant has met the burden of proof to be granted relief. I would give great weight to the Office of Planning's recommendation for approval. I'd also agree that the application as written and captioned is sufficient, and I would be in support of that application. I do note also the verbal support from the Office of Planning for the modification. I'd also note that DDOT has no objection to the approval. ANC 5B is in support. And clearly, a lot of people are very excited about this service. So I will be voting in favor of the application. Mr. Smith?
I agree with your assessment of this case, and it seems to me to be a fairly straightforward case at that. So I will also vote in the affirmative, yes vote for this special exception, this series of special exceptions.
Thank you very much, Vice Chair Miller.
Thank you, Vice Chair Blake. I'm ready to support the special exception and waiver requests that are before us, and I appreciate Vice Chair Blake and Board Member Smith's clarification in their dialogue with the Office of Planning and maybe the applicant as well as to exactly what relief is before us, and that we seem prepared to approve. So thank you.
Thank you. Okay, having deliberated, I'd like to make a motion to approve the application number 21327 as captioned and read by the secretary, and ask for a second. Mr. Smith?
Second.
Okay, the motion has been made and seconded. Madam Secretary, would you please conduct a roll call vote?
Please respond to the chair's motion to approve the application. Vice Chair Blake? I think you were on mute.
Yes.
Board Member Smith?
Yes.
And Commissioner Miller?
Yes.
Staff will record the vote as 3-0 to approve application number 21327 on the motion made by Vice Chair Blake and seconded by Board Member Smith, with Chairman Hill not present or participating.
Would you please call our next case?
Next is application number 21337 of CFC Incorporated. This is a self-certified application pursuant to Subtitle X, Section 901.2, for a special exception under Subtitle U, Section 511.1J, to allow a laundry facility in excess of 2,500 square feet of gross floor area in an existing detached one-story building. It's located in the MU3A zone at 2901 Minnesota Avenue Southeast, square 5507, lot 803.
Okay, hi, Ms. Wilson, how are you doing? All right, if we could, all right, if you could please, let's see, introduce yourself for the record and anyone else that'll be joining you today. I'd appreciate if you explain if you have any particular format for the presentation or if you're just however you're gonna do that.
Great. Thank you so much. Good morning. My name is Alex Wilson from Sullivan and Barrows. I'm the attorney for the case, and I'm here with Mr. Talati, who is the owner of Love in Every Fold, and he is the contract purchaser of the property. And we do have a presentation if Mr. Young could please pull that up. Thank you. If you could please go to the next slide. As I mentioned, I'm here with Mr. Talati, who is the contract purchaser of the property and the owner of Love in Every Fold, a high quality modern laundromat that he is proposing to open in this space. In terms of operation, they're anticipating 1 to 2 employees on site at a time, with a security guard from 8 p.m. to 6 a.m. for overnight hours, with 24-hour service available to those who cannot make it during daytime hours. The facility will include self-service options as well as wash and fold options with monthly community specials. There will also be a delivery service starting soon after the opening. The machines are modern, card operated, or even app operated, with the ability to view what machines are available ahead of time. The environment is also comfortable and quiet with no TVs. Charging stations are provided as well as Wi-Fi and folding stations, and there is no dry cleaning involved, just laundry services. In terms of the BZA request, the property is zoned MU3A, which is a commercial mixed-use zone. The building was most recently used for auto parts retail. This is a service use, which is typically allowed by right in the zone, except the regulations provide that laundry facilities specifically, which includes dry cleaning and the laundromat use, are limited to 2,500 square feet. Again, no dry cleaning is proposed here, but as this is a laundromat use and the building is approximately 7,500 square feet, the use requires special exception approval from BZA under the general special exception requirements. Next slide, please. This is what the most recent use looked like, and this is a view from Minnesota showing the large curb cut. As part of the proposal, we met with DDOT, and this curb cut is proposed to be reduced to 12 feet for one-way traffic through the lot. Next slide, please. This is an angle from 30th Street opposite Minnesota. And this shows the conditions on site and the 30th Street curb cut, which will also be reduced to 12 feet. And this will be the exit. And this area is going to be improved overall. The parking lot's going to be striped and appropriately screened. Next slide, please. This shows the internal floor plan proposed. Next slide, please. This is the plat, and I think this is a good place to discuss the 2 conditions that DDOT proposed. They have no objection, subject to 2 conditions, and the first condition is that the applicant shall reduce the curb cuts to 12 feet and have one-way traffic as shown in this particular exhibit. Per DDOT approval during public space permitting, and we are fine with that language. There's a second DDOT condition that the applicant shall remove excess paving and restore green space in the public parking and building restriction area around the property. We're also amenable to this, but it didn't include that same flexibility for the Public Space Committee approval. So if the board wants to adopt these conditions, we just ask that be revised slightly to also include that same language per DDOT approval during public space permitting, or the applicant shall work with DDOT and Public Space Committee to identify appropriate areas for removing excess paving, et cetera. It's a minor point, but it would allow flexibility for the second condition in case the Public Space Committee doesn't approve this. So we aren't back here to change a condition. And I have email correspondence with the DDOT reviewer confirming they're fine with that updated language. And I can.
So, quick question for you.
Yes.
If you had to do that, would you do it in non-public space on the property to increase the pervious surface? Well, how would that impact the plans that we have?
It wouldn't impact the plans that we have right now. My concern, and it's probably fairly minor, is that public space doesn't allow for demolition of some paving in that area. And then we have a reviewer who's reviewing this condition fairly strictly and says, okay, you have to go back to the BZA because they adopted this particular condition that says you have to remove and restore the green space, but then the Public Space Committee didn't approve it. And so we would be stuck having to come back to adjust the condition in an order.
Okay, but the green space is in public space that they need you to adjust, not in private space, correct?
So it's in the BRL, so it's technically private space and public space.
Okay, thank you. Do you meet the green requirements though, or the pervious surface requirements for the zoning? You do meet that currently.
Yes, we will be meeting.
And this would only increase the amount of green space that you have on your right?
Yes, all of that will be met.
Okay, thank you.
Thank you. Next slide, please. In terms of the use itself is a by right use if it were to be 2,500 square feet. So we are seeking the additional square footage for the entire building, requiring the special exception. And these are some photos of the existing location in Connecticut. So you can see how it looked inside and how clean and modern the space is. Next slide, please. Next slide, please. This is the help desk. Next slide, please. Next slide, please. Next slide, please. And next slide, please. In terms of community and agency support, OP is recommending approval. DDOT has no objection. We presented to ANC 7B and then the owner canvassed with the SMD this weekend, resulting in additional support noted by the SMD's statement in support. And prior to that, there was a separate petition that went around the neighborhood more generally, resulting in about 60 signatures in support. Next slide, please.
Ms. Wilson, before you're there, go back to that slide on the community support. The ANC 7B did not meet and vote on this, or do they plan to in the future? What's going on there?
So we presented and they voted 3-2. And I do not know the exact bylaws of the ANC, but that was not enough to move a formal resolution in support forward. So right after that, I had a pretty long discussion with the SMD, and then the owner, Mr. Talati, who's on now, talked to the SMD and actually went out with him this past weekend to go around and just make sure he was comfortable with the use, and they did additional canvassing, and I think they met over 50 people, and everyone was very supportive.
Do you know what the issues or concerns that were raised at those meetings with the ANC?
So I think the SMD was Mr. Hassan Tari was supposed to join us to talk more about that, and Mr. Talati might be able to shed some more light. When I talked to the SMD, and I don't want to speak for the other commissioners since it's sort of word of mouth, they were not clear on what the ownership structure of the business was. And they had concerns that it was more of a corporate entity coming into their neighborhood. And Mr. Talati cleared that up with the SMD immediately. once he called him and talked to him and met with him.
Okay. Do you anticipate that the 7B will have the opportunity to take this matter up for a formal vote at any point or again after you revisited it, or no?
That was not communicated to us that would be happening.
Okay, thank you. Mrs. Smith, do you have anything on that?
No, I don't have anything on it.
Okay, thank you. All right, thank you. Continues.
Great, thank you. I was just checking to see if the SMD was on. Next slide, please. So in terms of the general special exception requirements, they're met in this case. In terms of overall improvements, this will result in public space improvements, exterior building improvements, a redesign of the parking area, including a safer pedestrian environment with one-way traffic, as well as a screened parking area where there is only a chain link fence now. In terms of traffic, as noted in DDOT's report, they don't expect any impacts, and laundromats produce steady, predictable trips typically. The building itself is not being expanded, just upgraded and updated. There are no adjoining neighbors nor directly adjacent neighbors, as this is the only property in this square. The use itself is neighborhood serving, consistent with the purposes of the MU3A zone to provide day-to-day services and lower density commercial uses. And in general, the use is intended to be a positive addition to the community by activating a vacant retail building, improving the site, and providing a needed and exciting community laundry service. And this concludes my portion of the presentation, and I want to very briefly turn it over to the owner of Love in Every Fold, Mr. Talati, to say just a few words.
Mr. Talati, you there?
I think you're on mute, Chirag. I don't know if you can
Michelle, you
join.
can drop the slide. Are you done with the slides?
Yes, thank you.
You can drop the slides. Go ahead. All right.
Hi, good morning. How are you guys? So my name is Chirag Talati. Just a brief explanation of who I am. I'm the owner and operator for Love in Every Fold. I am located in 400 Blake Street, apartment 3202 in New Haven, Connecticut. And to kind of clear up some of the questions regarding the SMD and the ANC conversation about ownership structure, their question was who was going to be owning it. They brought up this third-party entity that is called Curbside Laundries, which is essentially a POS system that we utilize, and they have no bearing or ownership to this building or to our entity at all. I've been owning and operating laundromats for about 8 years, and I look to expand into this space. Canvassing this location about 2 times now, one by myself and one time with Commissioner Hassan Keith Towery. I was able to learn a lot about the environment, the people, and what they're looking for. And I am excited to actually be joining in and hopefully building this location and giving the community something to look forward to.
Thank you very much. Thank you very much. Does anyone on the board have any questions? Okay, thank you both. Okay, I'm going to now turn to the Office of Planning.
Thank you, Mr. Chairman and members of the board. My name is Matt Jessic, presenting OP's testimony in this case. And the Office of Planning can rest on the written record of our report. We are recommending approval of the application as it met the relevant special exception criteria. And that concludes my testimony, but I'm happy to take any questions.
Okay, I don't have any questions for Mr. Jessup. Does anyone else have any questions for Mr. Jessup? Okay. All right. I think, Mr. Young, is there anyone who wishes to speak from the public?
We have one witness signed up, and his name is George Tawe.
Okay.
Mr. Tawe is from our team. He's the project manager. So unless you have any questions for him, he's not a member of the public to testify.
Okay, fine. Thank you then. Okay, so I guess we can move on. Ms. Wilson, do you have any closing remarks?
Just to thank you for your time.
Okay. All right, Mr. Young, I'm going to dismiss the witnesses and close the hearing for now. We'll move on to deliberations. I mean, I believe that the applicant has met the burden of proof to be granted the relief in this case. My only concern that I had was with regard, and I would rest that on the report of the Office of Planning and their findings and their analysis. My only concern was with the community outreach, because I just thought it was interesting, a 3-2 vote, because it kind of said there was some degree of, concern. And I can certainly see issues with crime concerns and other things with a laundromat hangout, but it's unclear. So we don't have anything from the office from the ANC to give great weight to, but the endorsement from the SMD was positive, and the applicant's representations for having garnered the support of the community is also encouraging. But that's my only apprehension with regard to this. But I think otherwise, the applicant has met the burden of proof to be granted the relief. Mr. Smith, do you have anything you want to add or subtract?
No, I agree with all everything that you stated on this matter. I do believe they met the burden of proof for us to grant the special exception. I do like that the applicant has worked with DDOT to narrow to clean up the entrances to this site to make this a safer site to traverse, given that this is a triangular parcel. So there could be some conflicts that would occur with these with the two entrances that currently exist. I do share, some of your concern and apprehension about not receiving anything from the ANC officially. But I do agree with you as well that it is beneficial that we've gotten a letter from the SMD for that area recommending approval and support for this application. And we did receive testimony from the applicant to speak about how he would be a positive addition to the community. But it would have been great to get something from the ANC officially to provide great weight. But based on the testimony provided by the applicant and everything within the record, I will support the applicant.
Thank you, Mr. Smith. And I also would note there is a petition that the applicant has had several signatures on from members of the community indicating support for the project. Mr. Miller, or Vice Chair Miller.
Thank you, Vice Chair. Yeah, I agree that the applicant has met the burden of proof for the special exception that's being requested. I appreciate the applicant's responsiveness to community concerns and Office of Planning concerns. What you said, Mr. Chairman, just triggered in my mind a question I probably should have asked. Maybe you can remind me if the applicant, if Representative if Ms. Wilson addressed the security issue. The security, the pre-hearing submission, Exhibit 20C, says there'll be a security guard. This is a security guard will be present during the overnight shift from 8 p.m. until 6 a.m. By prioritizing a safe and secure environment with cameras, lighting, and modern safety measures. Customers will feel comfortable doing laundry at that hour, at any hour. This creates peace of mind for individuals. Safe space to do laundry during off-peak hours. Is the security part of the condition that the applicant addressed in their presentation? If not, I just maybe want to bring her back, Ms. Wilson, back and say if they have any objection to including a reference to the security that they're proffering.
It was not. Most conditions that were referenced regard the public space issues with DDOT, and that are really outside of our purview. However, I do think it would be helpful if you'd like her to bring back. How would we? I guess I'd reopen the record. And we can vote to. I guess we've done it, but we vote to reopen the record. You want to reopen the record? And I see good cause. I want to hear what you have to say.
I apologize for not bringing that up.
I think it's fine. Mr. Young, if you can bring back Ms. Wilson and Ms. Melhart. If I'm opening the room properly, make sure you let me know. If not, let me know.
You're fine. Yep.
Thank you. Ms. Wilson, you're almost there. You've heard the question from Vice Chair Miller. Would you be able to address that for us, please?
Sure. You're asking if we would be opposed to having the security condition or the security measures as a condition. And no, that's part of what we're proffering and that's part of the business. So if it's going to stay open from 8 to 6 a.m., we would have that security guard security measures as stated.
Thank you. Thank you for that response, Ms. Wilson.
Okay, Ms. Wilson. Ms. Wilson, can you tell me where we can cite the exact provisions of that in your document so I can have the proper wording on that condition to include the security provisions? And we'll just sort of tighten up a little bit.
Yes, give me 1 minute and I can identify it.
I think it's Exhibit 20C, page 2.
20C, page 2.
Yeah, the second paragraph addresses security, and the first sentence probably is the condition: a security guard will be present during the overnight shift from 8 p.m. until 6 a.m. But I'll let Ms. Wilson address that.
Yep, that's perfect. Yes, that would be perfect. The condition would be a security guard will be present during the overnight shift from 8 p.m. until 6 a.m. And that is on page 2 of Exhibit 20C.
Okay. That's great. Fantastic. Thank you very much, Ms. Wilson. We'll close the record. Excuse the witness. We'll go back to close the hearing. We'll go back to Mr. Smith. Do you have any objections with that or any other conditions you might want to add?
No.
Okay, so as for the DDOT conditions, I don't think we want to include them in our order. The intent to actually create more green space would be a positive. And I don't necessarily, it wouldn't necessarily materially change the outcome of the decision, in my opinion. What do you think?
I completely agree. It's within the right of way. And I don't think that that's something that we can control as a board. So I'm not inclined to include the DDOT conditions.
Okay. Vice Chair Miller?
I think the plans show the condition, the first condition of the DDOT condition about the one-way, reducing the curb cuts and having one-way from 24 feet to 12 feet and having one-way traffic in and out of each of those. So I'm comfortable with removing that DDOT condition, and I think and agree with what you said, Vice Chair.
Thank you. Okay. Having deliberated, I'm going to now call for a vote. I move that I make a motion that we approve the application as written and captioned with the addition of one conditional improvement with the addition of the inclusion of a security guard to be present during the overnight hours between 8 p.m. and 6 a.m. as stated in Exhibit 20, page 2. And ask for a second, Mr. Smith.
Second.
Motion been made and seconded. Would you please conduct a roll call vote, Madam Secretary?
Yes, and just to clarify, I think it was Exhibit 20C.
20C.
20C, yes, I'm sorry.
Okay. Please respond to the chair's motion to approve the application with a condition. Vice Chair Blake?
Yes.
Board Member Smith?
Yes.
Commissioner Miller?
Yes.
Staff would report the vote as 3-0 to 2 to approve application number 21337 with a condition on the motion made by Vice Chair Blake and seconded by Board Member Smith, with Chairman Hill not present or participating.
Right. Okay. Let's see. We have 2 more cases left. Is that correct? Or no, 3. We'll do the next one. Let's have the next one then. Thank you.
Next is application number 21331, Washington Metropolitan Transit Authority. It's a self-certified application pursuant to Subtitle X, Section 901.2, for a special exception under Subtitle C, Section 1305.2. The requirements for building mounted antennas under Subtitle C, Section 1305.1A, to allow antennas to extend above the top of the wall or roof of the building to which they are mounted. This is for 5 new building mounted antennas on an existing 11-story building. It is located in the D5 zone at 307th Street Southwest, square 464, lot 26.
Thank you. Is the applicant here?
Yes, Gary Ferrara.
Okay, Mr. Farr, would you please introduce yourself and who else might be on your team, and give me a sense of how you're going to do your presentation structurally, who else might be speaking, and we can begin. We'll have 15 minutes on the clock, and we can begin. But if you could just kind of give us the overview of and introduce the other members of your team that might speak first.
Yes, I am Gary Ferrara, the authorized representative for Washington Metro Area Transit Authority and Motorola Solutions, who is the prime project manager and construction contacts for WMATA. I have with me on behalf of WMATA, Vern Hartstock and Quasi Wright. I also have Paul Bromley with Motorola Solutions and Eric Cole with KCI, who is the engineer of record, in case there's any direct questions for them.
Okay, great. Thank you very much. Quite a team. Okay, you have 15 minutes on the clock. If you begin to tell us how your client meets the conditions for approval.
Okay, I do have a brief PowerPoint presentation that was submitted into the record.
Absolutely. Mr. Young, could you bring up the PowerPoint presentation?
Yes, thank you. So the property is Lafayette Plaza, the building at 307th Street Southwest. The building is owned by WMATA and serves as their headquarters. Next slide, please. WMATA in 2022, under order from the BZA 20799, received approval for a very almost identical application to install whip antennas, transmit and receive, and GPS antennas on the roof of the building, which exceeds the roof line. So we are asking for a similar relief from section 1305.2, which restricts antennas from exceeding the height of the building. Next slide, please. With this application, WMATA is in the need to add to their communication system and the antennas that are on the rooftop of the building. They are almost identical, maybe a little bit shorter than the existing antennas that are there. The 3 whip antennas that are proposed to transmit when receive will extend above the roof line 16.5 feet. The GPS antennas are a lot shorter. They will extend about above the roof line about 1.5 feet. Next slide, please. I went through, this is part of the record in my application, but I did include it from that. The requirements for building mounted antennas, it's very similar to documentation and testimony that was included in the relief sought in 2022. If you like, I've listened to the other applications. I can certainly go through it, but I did hear you say on other applications it's part of the record and may not be necessary.
Won't be necessary right now, right?
But I'm sorry.
It won't be necessary right now. You can continue.
Okay. So pursuant to subtitle 1305.1, which is the main relief that we're seeking, all building mounted antennas shall comply with the following conditions. The top of the antenna shall not extend above the top of the wall, a roof of the building, or structures to which it is mounted. We have indicated as shown on the drawings with the application, the antennas will exceed above the top of the structure for which it is mounted. As I stated, the whip antennas will be 16.5 feet above the roof line of the building that they are mounted on, and the GPS antennas will be 1.5 feet above the roof line of where they're mounted. So we respectfully request special exception approval from this requirement. Each antenna shall be located or screened, subject to visibility from the public spaces, navigable waterways, historic landmarks, national monuments, minimized to the greatest practical extent. The property is located in proximity to a number of public spaces, landmarks, navigation waterways, including Hancock Park, 1 block to its northwest, the Eisenhower Memorial, and the National Mall, a few blocks to the north, and the landmark HUD headquarters and GSA regional office building to the southwest and west, respectively. Washington Channel is located several blocks to the south. Next slide, please. The antennas are mounted to the greatest practical extent as their unobstructed heights are required in order to transmit and receive critical ops communication from all directions of the headquarters building. The antennas all are of the symmetrical, pole variety, which are whip antennas, and each measure only approximately 3 inches in diameter, and they taper to the top, so they are very, very slim. Given their vertically and very slim profile, the antennas are anticipated to be visually unobstructed. Further, with regard to views from the northwest south, the building is largely bounded by office buildings of between 7 and 10 stories in height. Notably, both the GSA building and the HUD headquarters contain a number of roof-level antennas that extend well above the rooftop structures. In case of the GSA building, the antennas appear to be mounted on top of the building penthouse and extend a number of stories in height. Given the property's location, new construction is reviewed by the United States Commission of Fine Arts, CFA, pursuant to Shipstead-Lucy Act. As a result, the CFA regulates the height, exterior design, and construction of private and semi-public buildings and adjacent to public buildings and grounds of major importance. I did reach out to the CFA the end of last year. They did respond. It is part of the record. They have no issue with the application, but they also stated that under the Shipstead-Luce Act, WMATA is exempt from their review. And that also is part of the record. Next slide, please. An antenna shall be constructed in materials of color that blend with the surroundings to the greatest practical extent, or shall be screened and are painted to blend with the surface to which the antenna is attached. As indicated in the attached drawings, the antennas are proposed to be constructed in materials and colors to blend to the extent practical with the surroundings. The antennas have a very slender upright appearance and will be constructed of light-colored metal intended to minimize contrast with the background sky. The proposed antennas will be similar in appearance to the existing antennas on the building. A building-mounted antenna placed on a penthouse or rooftop structure with a rooftop outdoor rec area space shall be secured from unauthorized access to minimum vertical distance of 10 feet. The proposed antenna's configuration complies with this requirement. The outdoor rec space is located at the opposite west side of the roof, and access from the rec area space to the area of the roof where the antennas are proposed to be installed is blocked by a portion of the enclosed penthouse. Any related equipment, cabinet, or shelter that is not internal to the building or penthouse shall be one, constructed of materials and colors that blend with the building, penthouse, or rooftop structures, and located to reduce visibility from public space to the greatest practical extent. This section does not apply as no outdoor equipment cabinets are proposed on the rooftop. Next slide, please. This slide shows the property where WMATA's headquarters is. It's the triangle in the center. It also shows the visual effects of the existing and proposed antennas. As you can see, location 1, actually it's to the upper left of the map image. The wording is cut off, but that's the view from that point. And then location 2 is to the upper right of the property. 4 is to the lower left, and 3, and then 4 is to the lower right. As you can see in 4, they're practically invisible. Of course, in location 3, because of the distance, they are not visible. The closer views from location 1 and 2 are a good representation of the visibility of the existing antennas and the proposed antennas. Next slide, please. The typical antenna view shows the existing antennas that are up there and what we are proposing. The second image are the existing antennas. The shorter ones, kind of with the circle on top of them, those are the GPS antennas in the forefront. And then the third image shows the addition of the antennas that are proposed and the shorter GPS antennas. Next slide, please. This is from the drawings that are part of the record in the application. It's the elevation view of the building, and it does show the existing antennas that are a lighter color and the proposed antennas that are bolder in color. Next slide, please. That's it. I would like to add that part of the record is the review from planning, and they outline the standards for the board on reviewing this request. They also have indicated agencies that they contacted, and there were no comments on the application. At the time, the ANC 6D had not responded. So I did submit as part of the record my communication with them since April in an attempt to review the application with them. And they did respond in April, which indicated no comments. I just looked, and this isn't part of the record, but they did respond on Monday, September 8th to the zoning office through an email stating that they have no comments on the application. we're available to answer any additional questions the board may have.
Thank you very much, Mr. Farrar. I think my biggest question came back again with the ANC, and I think you have adequately addressed what has transpired there. Are there any members of the board have questions for the applicant? Thank you very much. We'd like to hear from the Office of Planning.
Yes, good morning, Mr. Chair, members of the board, Karen Thomas, with the Office of Planning, and we have no objections to the proposed installation as it is no different to the existing, which was approved in 2022. These antennas are important to our service communications in the district, and they do meet all the requirements of having no adverse impact on the surrounding neighborhood. We also would note that the Commission of Fine Arts has no objection to this installation as stated in our report. And with that, I'll rest on the record of our report. Thank you.
Thank you, Ms. Thomas. Does anyone have any questions for the Office of Planning? Okay. Mr. Young, is anyone who wishes to speak?
We do not.
Okay, thank you. Mr. Farrar, do you have any closing remarks?
Not really. I think we've substantiated the need for the antennas, and a precedent has been set from the prior order from 2022, allowing the very similar antennas up there that were installed and operating, and obviously communication within WMATA's system is vitally important, and the purpose of the additional antennas is to enhance and improve that communication. I'm sorry, you're muted.
Okay. Mr. Young, you can dismiss the witnesses and close the hearing. Thank you very much for coming on. Okay. Okay, we're all here. All right. I reviewed the application, and I do believe the applicant has met the burden of proof to be granted the relief. The most significant thing in this application for me, we've gone through the entire checklist with the Office of Planning and with the applicant in detail, and I do believe they have met the burden of proof based on those criteria. The biggest issues for me when I look at this thing is the visual intrusion issue. And in this case, I do not think it'll be visually intrusive at all because of its the height of way up 130 feet. I think that this fact that the singular block makes it, stand up by itself. You get the CFA support, community finance support. I was a little bit disappointed in not hearing from the ANC again. I did acknowledge the communication that transpired between the ANC and the applicant in those emails they put in. I'm comfortable with that, and I will be in support of the application. Mr. Smith.
I have nothing to add, Vice Chair Blake. I agree with your assessment of this particular case, and will vote in support, noting that CFA doesn't have any objection.
Vice Chair Miller.
Thank you, Vice Chair Blake. Yeah, I agree with each of your comments, and appreciate the applicant's presentation, particularly the illustration or rendering showing the existing slim profile color that blends in somewhat, and I think that was very helpful, and certainly want to support the essential functioning of WMATA in this area. So I'm ready to support.
All right, thank you, Mr. Vice Chair. Okay, based on that, I'd like to make a motion to approve the application as written and captioned for application number 21331, and ask for a second. Mr. Smith.
Second.
Madam Secretary, the motion's been seconded. Would you please call roll call vote?
Please respond to the Vice Chair's motion to approve the application. Vice Chair Blake.
Yes.
Board Member Smith
Yes.
and Commissioner Miller.
Yes.
Staff would report the vote is 3-0 to 2 to approve application number 21331 on the motion made by Vice Chair Blake and seconded by Board Member Smith, with Chairman Hill not present or participating.
Thank you very much, Madam Secretary. It is now 12:01. I'd like to take a 30-minute lunch break and reconvene at or about 12:35. Okay, thank you. Madam Secretary, could you call us back into session, please?
The board is back from its lunch break and is returning to its hearing session. Would you like me to call the next case?
Please, thank you.
Next is application number 21334 of Della Barba Company. This is a self-certified application pursuant to Subtitle X, Section 1002 for a use variance from Subtitle U, Section 320.1A to allow restaurant use, and pursuant to Subtitle X, Section 901.2 for a special exception under Subtitle C, Section 703.2 from the minimum vehicle parking requirements of Subtitle C, Section 701.5. This is for a restaurant on the first floor and basement of an existing two-story row building with outdoor seating and public space. It's located in the RF1 zone at 1382 East Capitol Street Northeast, square 1035, lot 814.
Okay, thank you very much. If the applicant is here, would you please introduce yourself for the record and anyone else who will be joining today in the presentation?
Anthony, you're on mute.
Hi, I'm Joe.
Okay.
Sorry. For the record, I'm Anthony Rochelle, attorney for the applicant, Della Barba Pizza Company. Also,
thank you,
with
sir.
me.
Who's here with you today? Who's here with you today?
With me today are members of Della Barba Company, Tracy Wingate and Joseph Barber, and our architect, Zaid Damini.
Barber.
Of Damini and Associates that will be making a presentation regarding the proposed plan.
Okay, thank you. Mr. Riddell, I have reviewed the application and I'm not sure we are in a position to proceed at this point. There seems to be an issue with we do have a report from the Office of Planning. They reached out to you for some questions and they were not you didn't respond to them. For example, there was some issues with the self-certification that said something about the seeking variance from U 320.1. I'm not sure exactly about the relevance of that to the relief that's actually being requested. You have a non-conforming use to non-conforming use with an expansion into potentially with the increased seating in the street and the sidewalk. That's kind of what you're asking for, but the U 301.2 would not get you there. The other thing is the question about parking relief being requested. It's unclear that you need parking relief in this application. Now, when you went through your written remarks, I saw that you had touched on relief from Subtitle C, Section 204, which does address the issues that you talked about with regard to non-conforming use, changing a non-conforming use in a residential zone and expansion. So I do think you've got the substance of your discussion there, but you need to make sure that's in the self-cert application because we cannot give you relief for something you don't ask for. And essentially the way this is written, you haven't asked for the relief that I think you need. But again, if you look at Subtitle 2, Section 204, I think you directionally have gone in the right direction to get that done. However, we might also point out that when you look at Section 204, or those are variances which are fairly high bars to meet. So I do think you have to be careful in looking at. Now, the board can't tell you what to do. I can't. It's a self certified form. You can do whatever. You can ask for whatever you'd like. But if we don't think it's what you appropriately should be asking for, we could dismiss the case. But I wouldn't want to do that. This is obviously something people really like and want in the community. So we just have to make sure we get the right request in place so that you can accomplish what you're trying to do. I'm gonna first ask, do you understand what I'm saying?
Yes, Mr. Chairman. We did address the planning office issue with regard to the parking. That was addressed by the Department of Transportation's report, which we noted that there's only one space required. Because we are going from a non-conforming use as a fast food operation to a non-conforming use as a restaurant, which allows us to expand into public space, we have to meet a parking requirement. And that parking requirement was for only one space, given the size of the facility and the exemption allowing for 3,000 square feet not to be included. There's only a 1,000 foot area involved, which requires the one parking space.
Okay. And with regard to the variances that you're requesting, there are different ways to get to where you want to be. And I think you just need to make sure that the self-cert aligns itself with the application. So U 320.1 is not the request. But as I said before, in your written statement, you do very carefully go through a lot of the Section 204, which you will need relief through that mechanism. So you've covered the issue, but it needs to be in your self-cert statement up top, okay? And again, it's a high bar. So you might want to think about ways you might get there other than that particular one. Mr. Smith, do you want to add something to that?
Yeah, so I have two things I add, and a fair amount of your expansion seems to be forward of that front building wall. It's the open question to me of whether how much of that is public space, how much of that is private property. That's not really. We need some additional clarification on the plans that you submitted. What's public, what's private. So that's one additional request. The second one, I want to piggyback off of what Chairman Blake stated. You're requesting a variance, use variance. That is a very high hurdle. So remember that you have to demonstrate a hardship here. And I don't know, based on, and this will get fleshed out a little bit more, I guess, as we, this will be continued because we need some additional information. I don't know if you've met that hardship criteria, if there may be other options within the zoning regulations that you could pursue to operate the use in a manner that I think that they are intending to operate it as. And again, as Chairman Blake stated, you can request what you want, and the board will make a determination at that particular time when the application is complete, is submitted to us. But there may be an opportunity, and I'm not making a determination. You may want to explore this provision of the corner store regulations a little bit more closely, whereby you may not need a variance. So I just want to put that out there as you refine this application before it comes back to our board.
I would like, if we could, to proceed with the presentation of the plans, because those will not change, so as to familiarize the board with what is being proposed and what the ANC has received and approved.
Yeah, I'm hesitant to do that only because I think it'd be better to have the relief in order, because we can't take action on anything that's before us right now. So we would definitely need to get that in a different form, even for us to take action today. So in fact, what I would suggest, if you could, would be to work with the zoning administrator. We can't give you a determination right now, and I can't shape it. What we've already seen tells us that we need to make some adjustments. And I think you've gotten two bits of information as to where direction you might go in with this already. But I do think if you spend some time with the zoning administrator to get us and the Office of Planning to figure out the best exact route, this is something I think the community is excited about, and I think you just need to get the relief requested in order and kind of approach it from that perspective. I I don't think it would be really beneficial at this point to go through the specifics of the application without that in place. Vice Chairman Milner, do you have anything you want to add?
Thank you, thank you, Vice Chair Blake. Yeah, and welcome, Tony Rochelle, to the BZA. It's good to see you.
Same.
We worked 40 years ago together in the same building, district building, or it was called the Wilson Building. But anyway, I agree with the Vice Chair Blake's comments. I think it would be helpful to, and we need an Office of Planning full report. I'm not sure we have that. I do commend you on your community outreach and at the ANC and garnering support from unanimous support. I think it was from ANC 6A, and I think this will be an amenity in the community. But we do have to have. We have to have the right relief before us to grant the relief that you need to do what you want to do. So I think if you can get something from the zoning administrator who does determine that, that spells out exactly what you should be asking for and what you don't need to be asking for, that might be helpful. Or the self-certification, revised self-certification form, as indicated by my colleagues. So I look forward to you're getting that soon and are being able to review this as soon as possible.
Thank you very much for your comments.
Vice Chair. Madam Secretary, can you help me a little bit here with the scheduling? Because I'd like to try to move this on as quickly as possible. What would be the best time that we could bring back the applicant to work through this? I would suggest about a month or two.
So I would suggest at this point, November 19th. I know it's a couple months away, but the schedule is pretty full for the fall. And this could potentially give enough time to get answers from DOB if needed and for OP to file a full report. I'm not sure if that would work.
Would that work for the applicant?
Yes, it would.
Okay, thank you. And we'll do that. We'll postpone until the 19th of November. And again, I would just encourage you, there are many ways to skin a cat, and some of the ways require far less of a burden in terms of the heavy lifting, in terms of the, the standard for approval. As you know, a use variance is very challenging. High standard, a high bar, a special exception is a much lower bar. So there may be some ways that you can address what you're trying to do. And you should consider it. I can't tell you what, but again, if you spend some time in those with the ZA's office, I think you'll be able to come up with something. Okay. Thank you, guys. Thank you very much.
Thank you.
Thank you. Okay. Mr. Young, we can close and dismiss the witnesses. Okay. Madam Secretary, would you please call our last case of the day? You're on mute.
Sorry. Next is application number 21333 of Parasol Tree Holdings LLC. This is a self-certified application pursuant to Subtitle X, Section 901.2 for a special exception under Subtitle E, Section 5201 from the lot occupancy requirements of Subtitle E, Section 210.1, and pursuant to Subtitle X, Section 1002 for a use variance from Subtitle U, Section 301 to allow an office use. This is for a new office use on the first floor of an existing 2-story attached building and 3-story rear addition for residential use. It is located in the RF1/CAP zone at 409 East Capitol Street Southeast, square 817, lot 812. And as a preliminary matter, there is a request for party status in opposition to the application from Frank Snellings and Mary Landreau.
Okay, so we'll address the party status question first. Is the party asking party status present? Mr. Lyle, Mr. Blanchard?
Yeah, let's do that. Can you hear me?
Yes,
Yes.
I can hear you. I can't see. There you are. Okay. I see that everyone looks like they're here.
Okay.
I've reviewed welcome back. I should say that first. Welcome back. I reviewed the request for party status and the owners of the abutting property, in considering the nature of the requested relief, as well as the issues and concerns raised. I do believe that the requested interest would be more significantly and uniquely affected in character than the general public. So I would feel comfortable granting party status if my board would be comfortable with that. Mr. Smith?
Yes, I'm comfortable with that.
And Vice Chair Miller?
Yes, I support the party status request.
Okay, so I will then go ahead and make a motion to grant the party status in application 21333, I believe, to Mr. Snellings and Ms. Landreau, the budding neighbors, and ask for a second, Mr. Smith.
Second.
Okay, motion is made and seconded. Madam Secretary, will you take a roll call, please?
Please respond to the chair's motion to grant party status in position. Vice Chair Blake,
Yes.
Mr. Smith,
Yes.
Commissioner Miller.
Yes.
Staff record the vote as 3-0 to 2 to grant party status in opposition on the motion made by Vice Chair Blake and seconded by Board Member Smith.
A quick comment to Mr. Blanchard. As you're aware, having party status, you'll be given an equal opportunity and an amount of time to present as the applicant, including your witnesses. You'll be able to ask questions, cross-examine all the witnesses and so forth today. Are you prepared with your materials?
Yes, Vice Chairman Blake. Mr. Young has some materials that I'd like to use as exhibits. They were filed with a Form 153 yesterday morning.
Okay. If those, Madam Secretary, I assume those have met the deadline and they are submitted properly, correct? If not, we'll submit them into the record.
They should be in the record.
Okay. So with that, we'll begin. Mr. Sullivan, welcome back. If you could introduce yourself and anyone else with you speaking today, and you could talk a little bit, I appreciate that.
Thank you, Chairman Blake, and good afternoon, Chairman Blake and board members. My name is Marty Sullivan from Sullivan and Barrows here on behalf of the applicant. And with us today also is Brian Forehand, the project architect, and the applicant, Tony Gia, should also be with us.
Okay. Let me just introduce the party in opposition quickly, and then we'll begin with your presentation. Mr. Blanchard, would you introduce your team, who's with you, and who will be speaking, just so I have a sense of that?
Yes, thank you. Sitting next to me here, looking at his cell phone, is Mr. Frank Snellings, and his wife, Mary Landreau, is not with us yet. She's tied up in a meeting, but hopes to be back and available by 1:30. Our other witness, Jeff Levin, is hopefully on the phone, but I'm going to send him a text message. And his wife, Daniela, is not with us. It's myself and those three people are there's Jeff. He's on the screen by phone, I believe.
Okay, thank you very much, Mr. Blanchard. Is there anybody from the ANC here? I don't think so, correct? No. Okay, good. Okay, Mr. Sullivan, I apologize. I'd like for you to please, again, formally introduce you. I think you did. If you can just explain to us how your client is meeting the criteria for approval. You've got 15 minutes on the clock. Proceed as you will.
Thank you, Mr. Chairman. If Mr. Young could please load the PowerPoint presentation. So the property address is 409 East Capitol Street, Southeast. Next slide, please. Property contains currently a two-story building with a commercial use on the first floor and a residential dwelling unit on the second floor. The first floor has operated with a commercial use for over 75 years, most recently as office space for Sanabria and Company, an interior design firm. And previously it was a dry cleaning drop-off facility. And the prior owner of the subject property changed the use from dry cleaning drop-off to the office space, and the necessary approvals, which would have required a use variance at that time as well, were not obtained at that point. So when the applicant, after he purchased the building, began investigating this property for the proposed project, they were informed by us that the office use was not compliant because it had a dry cleaning C of O and there was a change of use, and that this use variance would be required. So through this application, the applicant seeks to correct this previously unauthorized change and to bring the property into compliance with use regulations. And specifically, the applicant's requesting the use variance under U301 to permit conversion from one non-conforming use to another. While the 1958 regulations allowed this as a special exception, the 2016 rewrite removed language that essentially makes the provision meaningless and unusable. So there is no special exception anymore. So all these cases have been use variances, and there's been maybe 7 or 8 of those since the change in 2016. The applicant's also proposing to construct a rear third-story addition to the building, or a rear addition with a third story, and will add a second residential unit. So it will have the remaining office use and 2 residential dwelling units in the end. The proposed addition will increase the lot occupancy to 70%, exceeding the max of 60%, and requiring this special exception relief from E210. Next slide, please. The Office of Planning is recommending approval of both areas of relief. ANC 6B last night voted unanimously in support of the use variance and voted 6-2 to oppose the special exception request. ANC 6C, which is also a party, they are across the street, across East Cap. They unanimously voted to support the application, both areas of relief. And the architect of the Capitol has submitted a report with no objection. Next slide, please. Regarding the general special exception criteria, the project preserves the property's longstanding mixed-use character. It adds needed residential units, a unit, and respects the scale and historic fabric of the Capitol Hill Historic District. And the addition does not extend more than 10 feet past either adjacent building's furthest rear walls. Of course, we'll go into that in more detail regarding the special exception test coming up. Next slide, please. The special exception criteria for 5201 for this 10% additional lot occupancy. The proposed addition is only 10 feet past the furthest rear wall of the building at 411 East Capitol Street. And it aligns with the furthest rear wall of the building at 405 East Capitol Street. We still have a proposed rear yard setback of 30 feet, which is 10 feet more than the minimum required. And the shadow study, which Mr. Forehand will show you, shows some slight impact, but certainly not undue impact. Regarding privacy, there's no windows on the sides of the proposed addition, and the small roof deck proposed is closer to the front of the building, and it doesn't have a view of the rear yards because the rear addition is sloping down, so it doesn't have a roof deck. And the sightline drawings that you'll see show no view of the addition from East Capitol Street. Again, we have a rear yard of 30 feet. This is regarding character scale and pattern. Max height at the highest point of the sloped roof is 29.5 feet, which is 5.5 feet under the maximum. The historic part of this enjoys support from CHRS. They didn't weigh in on the zoning part of this. And also has approval from HPRB and, as noted, from the architect of the Capitol. Next slide, please. There's additional criteria because of the zone we're in, because we're in the cap overlay. And this is also addressed by the architect of the Capitol letter. So I think I'll just refer to that letter, and the information in detail is there on how we have met these requirements as well. Next slide, please. Variance test for the use variance. I will note too, the use variance is supported by all parties, even the ANC 6B, which is opposing the special exception. They're unanimously in support of the use variance. And we haven't to date heard any objections at all to this part of the application. The property is unique due to its long history of this ground floor commercial use. Originally a dry cleaner with C of Os dating back to the 1950s. I mentioned that under prior ownership, it was converted without the proper approvals. Undue hardship, a strict application of the regulations would create undue hardship. The first floor cannot reasonably convert it to residential use without substantial reconstruction, which is cost prohibitive. And it's also inconsistent with the building's historic design. I think Mr. Forehand, if you have questions about this, could explain too how HPO's guidelines, historic preservation's guidelines, would restrict changes in the display window and other front design things that would have to be changed in order to support a residential use behind it. No harm to public good or to the zone plan. Granting the use variance will not harm the public good. The office use is less intense than the historically approved dry cleaner use. And I'll note that we're not asking for an expanded category of uses like we sometimes do. The owner wanted to just keep it as office use and didn't see any need to expand that for any other possibilities down the road. And the relief will bring the building into compliance while supporting local business and maintaining neighborhood stability. Next slide, please. So I'll turn it over to Mr. Forehand to take you through some photos and the plans. Ryan?
Thanks, Marty, and thank you everyone for your time today. So the project is illustrated here is a mid-block two-story building, currently 409 East Capitol Street. Next slide. And the images here show the rear of our property as well as the two adjacent properties. Next slide. And a closer view, just the existing rear of our current building. As you can see, it's sort of a step down property as it extends towards the rear and currently does not extend as far back as either neighboring property. Next slide. This is in the documentation that we provided. It basically just provides some background on the property, including the residential and commercial square footage. The main thing of note here is that the residential square footage is the predominant use based on the calculations of the square footages of each use. Next slide. This is our existing site plan. Again, just illustrating the location of the property. Important to note here as well, just sort of the assemblages of the properties adjacent. Also the fact that there are no public alleys from any of the adjacent streets. It is essentially a landlocked parcel. Next slide. We both 3 years ago when we received initial HPRB approval of the project, and again, this go round did massing studies of the property to show both the existing and the proposed impacts on the site. So this is just showing the existing rear facade and the associated massing. Next slide. And we also illustrated both via the documentation and also an erected lumber mock-up that the proposed addition is not visible from any point along the street as required by HPO. Because of this and the fact that even with requesting the additional relief, it materially does not change what we had applied for in the previous go round with HPO. They did not see any reason not to accept the proposal again on the merits this time. So it has already gone through HPO and was approved on consent calendar in July. Next slide. And then this shows the preliminary elevations of the project. And again, it is important to note that we have gone, we're going through a preliminary review. So because we first want to confirm what is possible for our client before we spend time, designing something that may or may not be approved later, we have not developed obviously final plans or elevations for the project, but this illustrates, our preliminary concepts for the project. Next slide. And likewise, this is showing the proposed property seen from the 405 and 407 adjacent property looking towards the west. Next slide. And just for reference, this is showing the site plan with the two neighboring properties. This is our current existing footprint of the existing two-story building. And then next slide, please. Illustrates then our proposed addition. So as you can see here, we are extending 10 feet, but not beyond 10 feet of the 411 East Capitol Street property. And we are extending the same distance as the 405 East Capitol Street project, or 70 feet, so a remaining 30 feet setback. Next slide. And then these images effectively show the massing envelope and the impact. This view here does also illustrate the proposed roof deck, which is Mr. Sullivan indicated is towards the front of our building and adjacent to the side property wall. So it is not something that would have an adverse impact on the privacy of other adjacent property owner. Next slide. And then this is looking towards the rear, towards the property to again illustrate the massing. And again, you'll note that the setback of our building, or the extent to which it is extending, is equivalent to the 405, 407 property to the west. And then you'll note several properties to the east actually still extend further than what we're proposing. Next slide, please. And just another view illustrating the same massing from the opposite side. Next slide, please. And then finally, as is required, we have provided the shadow study. So the images at the top are based on the matter of right 60% lot occupancy, and based on what was previously approved by historic, which was all done as a matter of right by right. design. And then the lower is showing the impacts of the additional 10%. So the percentage of the little parts that are highlighted in red on these diagrams, that indicates the additional shadows that would be cast by what we're proposing. So you can see the minimal impacts that doing this additional 10% that we're requesting would actually have on the adjacent properties. Next slide, please. This is showing this the same at the summer solstice. And then next slide, please. And then at the winter solstice. Next slide, please. I think that might be everything.
Yes, that's it for the presentation. If the board has any questions for myself or Mr. Forehand or Mr. Gia, thank you.
Sure. Sure. Thank you very much for your presentation. I want to actually first start with Mr. Forehand and get a little clarity on a few things. I understand that this is a preliminary look at it, but I wanted to get a better sense of the actual project in terms of where the addition is going to be. I know you had a slide early on that had the kind of the additions to the floor, but could you just go back and kind of talk about how much will be added to the first floor, how much to the second, how much to the third, and how those three would connect? How, for example, how would I enter into the residential space? Where would the commercial space terminate? Those sorts of things. I think you had a couple of exhibits in it that alluded to it. I wasn't able to really follow it well.
Yes, I'm happy to do that. And I don't know if it's possible.
And if I could jump in, Mr. Chairman, I didn't include the floor plans in the PowerPoint presentation, but they're in Exhibit 20B, which is the more complete plan. So there would be floor plans in there. And maybe, Brian, you could look at them on your screen and explain them as the board looks at them on their screen, if that's possible.
Yes, absolutely. So see if I can give you a little bit of what page you might be able to find this information.
And can I also, since we're bringing up these floor plans, the floor plans don't necessarily speak to where the units are within the building in the proposed set. I see existing floor plans for a residential unit on the second floor, but the proposed set doesn't provide much detail. So could you provide that detail if we're pulling up those plans?
Sure, certainly. So I believe it should be page 19 of the BZA submission that's in the file that shows the ground floor plan.
I think 19 is amassing.
Okay, yeah, sorry. I think this, sorry, what I was referring to, I think what was in the full file, not just our presentation.
Oh, okay. So you're saying,
Sure.
yeah. You know, Mr. Young, it would be helpful if you could just, because I'm trying to scramble to get it myself. Could you pull up the Exhibit 20 and the page that he's talking about so we can all just be on the same page? Literally.
And as you do that, the one thing I will say is that, you know, that we intend to maintain the office use on the ground floor. Residential would be predominantly second and third floor. There are some access areas of access on the first floor that would be for the residential units and some utility and storage, but that's, you know, not the material use. The use of the residential would be on the second and the third floors. So as that's being pulled up, we're adding approximately
Mr. Young, do you have it? Okay.
Yeah. That's great.
Let's start on page 14.
Perfect. Yes, thank you. So as you can see here, we would be adding approximately 387 square feet to the first floor. And this is where, as I mentioned, this would be largely providing rear circulation to the back, the rear yard area, and would be effectively utility space for the residential units in terms of hot water and so forth. We wouldn't have any occupied residential space down here in terms of living quarters. We would not be expanding the office use here, and that's effectively because of the fact that it's grandfathered in. We're not at liberty to expand that space or square footage. And then if you go to the next floor,
Before you go to the next floor.
Oh, sorry. Yeah.
Yeah, I see the 387 square feet that's being proposed as this utility space for the residential. But you do have a series of doors that would access the ground floor commercial space. And would that be towards that would be dedicated towards the commercial? You see what I'm saying? Not the double doors, but the other set of doors that connects through 3 doors to the ground floor.
Right. And sorry, it may be helpful to go back one page just so everybody is seeing the same. So we can go back to the first floor plan. Thank you. Yes, so the door to that's above the bay, as we're looking at this plan north, that leads to a series of steps. That's the residential entry into the building, and that would be maintained as the residential entry. Looking to the from the sidewalk, the door below the bay, that accesses the office space, and then there are a series of doors out the back. So they go to basically like a storeroom space currently, and then we would be adding a shared space to the rear there that would be effectively a egress for that tenant. And then the double doors, as you mentioned, that would effectively just be coming into a common space, and then stairs that would be leading up to the residential floors from the rear yard.
Okay, thank you for that clarification. But wouldn't that be contrary to what you just stated, that the ground floor commercial space you're not proposing to expand? Because that is expanding the space accessible to the ground floor commercial that is currently there, I believe.
I mean, we could honestly, I mean, it could be through shared space. The space just before what we're showing actually is also that sort of room that you pass through. That actually is where there are some current utilities that are currently shared between the commercial and the residential space. And honestly, I mean, given the square footage of the space, it's more of a courtesy for the commercial use, but I don't, believe from an egress standpoint, we would be required to have that second point of egress. So,
well, either way, you're requesting a use variance here. I'm saying that would be considered an expansion, just contrary to what you're stating. But you can continue on with your presentation.
Okay.
And if I could jump in for a second, Board Member Smith, we're definitely not asking for an increase. So it could be a condition of any approval to make it clear that whatever was approved before is all that gets approved now as far as the premises footage. I noticed the C of Os, I don't know that they just say the first floor of the building right now is what that so whatever the existing first floor commercial use is, yes, can't be expanded. We certainly aren't asking for more. So we could either clarify the plans or do whatever it takes to make that super clear.
Okay, we can mull it over. So Mr. Forehand, you can continue with your presentation. I'm sorry.
Okay, no worries. And then if we go to this next slide, that'll show the second floor with a proposed addition of 585 square feet at that level. And then and this is also depicting sort of roughly the idea for the 2 units. Again, this is preliminary, but this level is mostly occupied by a single unit that would have views towards the front, presumably living space, and then towards the rear, presumably bedroom space. And then you'll note that there is another entry and stairs that would provide access into the upper unit. So you would effectively come into a lower landing and then take the stairs up to the 3rd floor, which if we go to the next page, we'll be able to see how that floor lays out. So it's an additional 648 square feet single use residence with the roof deck situated at the front as previously indicated.
Okay, I'm also unclear because you're not showing walls, you're not showing where.
Correct. Yeah. I mean, we haven't designed the interior of the space because, you know, doing so and then not being able to actually build the property would be sort of a waste of our client's money.
And I know
I've never seen it done that way, but that's interesting. But okay.
I understand. Yeah, we typically we do have like a little more advanced floor plans, but the zoning administrator does have the there's total flexibility with any approval like this to change the floor plans, but I do know that we typically do have them a little more detailed than this one.
You mentioned a little while ago, Mr. Sullivan, about the C of Os. So you have a C of O from 2 C of Os were in the record from like 1958, 48, 1950 or something like that. Is that right?
Yes, that's what I see. Yes.
Okay. So at what point do we have a C of O at all for the building?
Well, we just have a C of O for the commercial use because the residential unit doesn't require a C of O.
Okay, we do not have that at any level other than that?
No, it wouldn't be required. So typically on mixed use with the mom and pop, you only have the commercial C of O.
Okay, so when the applicant acquired the property, they did not get an updated C of O, is what you're saying?
Well, yeah, I mean, more to the point when the previous owner changed tenants, the current tenant, which came on board under the previous owner's tenure, that tenant did not get the necessary approvals to change it to get a C of O. And so they've never.
When did the dry cleaner cease to operate?
I think I could like to bring Mr. Gia in if he's there. He could best answer these questions. Tony, are you there? He said he called in.
There is someone here with a 703 number.
We're asking him to unmute. Maybe he was muted.
Okay.
He says he's having technical difficulties. The current office use moved in 2 years before he purchased, and of course, so I followed up with the question on when he purchased. So I'll give you that answer in a minute too. it should be in the record too, so I'll look and see where we have that.
So as you understand, it was converted to, let's see, the office use 2 years before he acquired the property. That's what you're saying?
Correct.
And was there a different tenant in the space at that time? Or was this the current tenant, the original tenant? Post cleaners?
To answer a previous question, my client purchased this property in 2021. So Sanabria started in 2019. And so is your question was,
You're saying they took your, so at 21, so in 2019 is when the current tenant moved in, or when the conversion took place?
Yes, current tenant moved in 2019.
2019, okay. Now, was the applicant required to get a business license to operate the rental property?
I don't know the answer to that. I assume so, but it's not my area.
Ask him if he has a rental license to operate the property. And secondarily, I would assume that the current tenant as well has a business license to operate at this location. Is that right?
I don't know.
Okay. All right. So I would like to just check out those two pieces of information, because in order to get a business license, you need a C of O. So I'm trying to see if the rental property is being rented legally, or if the business is operating. I'm sure it is. I'm sure they probably pull, a business license, so it must have a C of O that we just can't find.
No, I know there's no other C of Os in the property other than the ones we've submitted.
Okay.
From our search.
Okay, so we just have to figure out how we got to where we are then. Okay.
So I mean, how in a typical commercial lease, the tenant's responsible for ensuring that they're in compliance according to the lease. Now, I understand ultimately a property owner would be responsible as well, regulatory wise. But in this case, that's how that came about. Sanabria, the office use, when they came in, I assume they thought that everything was kosher, and they just didn't get a C of O. And so Mr. Gia, who purchased in 2021, and when he called us to talk about the special exception case, we looked for C of Os, and when we didn't find one, we told him that he needs to shore that up as well.
Okay. All right. So I just want to, when he's available, we can get a little more better clarity on that. That would be very helpful. So I guess this building, was it marketed as a multi-unit building, or was it marketed as a residential building when he purchased it? Do you know?
No, I don't know offhand. Multifamily is what he says, but
it's a multifamily.
Well, maybe they meant multi-unit, but I mean that would just be a broker's representation of what was there. It's one unit and one business space, so I don't know why they would do that.
Okay, you had indicated that this was a non-conforming use to non-conforming use transfer. So essentially, that would be something that would be able to be accomplished typically through a special exception, and then through an area variance because of the using non-residential space, using residential space. In this instance, it's a use variance because it looks to me like the non-conforming element has lapsed. So what you're really looking at is a green, start off, you've got a residential property that you're trying to now put a commercial facility in, because that it has lapsed. If it hasn't lapsed, please explain to me why it would not have been.
So it has lapsed. That's one reason. But even if it had not lapsed, this would be a use variance. In the 2016 rewrite, for whatever reason, the phrase neighborhood facility was removed from the regulations that provide for a special exception change from one non-conforming use to another, neglecting the fact that every single thing ever approved under that was a neighborhood facility, because it's the only thing that could possibly approved under that, or that anybody would request. So now the language says you can change from one special exception or from one non-conforming use to another by special exception, as long as you're a single family dwelling, a flat, or a multifamily property, which is impossible. So when the office use was started without a lapse in 2019, their request would have been a use variance. And now it's lapsed and it's still a use variance. So in either case, from September 2016 forward, these were all use variances. And all the cases that we mentioned in our applicant statement, we've done 4, 5, or 6 of these cases since 2016, which would have been special exceptions, but now they're use variances. We detailed those cases in the at the end of the applicant statement.
Sure, we saw those were mostly, well, some reorders primarily. The question I have though is, if it's a use variance, I agree, but it's a use variance because as it has lapsed though, it's not going from one non-conforming to another. And I think it is basically, the way we would look at it is it's a residential building, oddly configured, that is that you'd like to convert to a commercial space.
No, it's a resident. It was built as a commercial space. The 4 properties to its left as you face the building, all the way to the corner, are built the same way. They're all commercial spaces on the first floor. They're all mixed space in the residential zone. While it lapsed, it needed this relief anyway. Like I said, in 2019, and we're correcting that. And we're not asking to change a residential space to a commercial use. We're asking to keep the commercial use that's been in existence from the beginning, more than 75 years. And that's what's configured. And if you look at the photo of the front of the property as well, it's built as commercial. It's flush to the ground, whereas the residential properties around it have the elevation, stoop. It's got the display window, which historic wouldn't allow us to change. And I also note that everybody supports this heartily, even the people that oppose the special exception. So I would not agree with the characterization that we're asking to change a residential space to a commercial space. We're just asking to retain the commercial space that's been in existence from the beginning.
Right. I agree with you that in the difference between this building and the ones beside it is the fact that right to have a non-conforming space has lapsed in this case, whereas in those cases it is not.
Well, yeah, it hasn't lapsed, but actually if anybody changes the use, whether it lapses or not, they're going to need this use variance. And of the precedents that I detailed in my applicant statement, some of those are lapses and some of those are changes from an existing non-conforming use to another. For instance, I
believe the examples you gave us were summary orders. I didn't see any full orders in what you gave me. So I'm trying to get there. So I'm just saying, I looked at it, I said, these are summary, I can't use any of this. So, but I don't know what the logic was behind it. And each one has a nuance, right?
I could go into more detail if you want. I mean, I would, and we did, this happened in another case that we have, like,
can I interrupt as well, since we're going down this road? And Mr. Sullivan, as you know, each case stands on its own merit. I get the case history, but any decision that we would make would stand on its own merits in this particular situation.
very aware of that maxim, that it stands on its own merits. It doesn't stand on its own law. It doesn't mean that the board can take a consistent pattern of custom and practice in how they view and consider these applications and then say, well, even though the facts are very much like every other case, the merits are the same as these other cases, that we're going to go in a different direction here. So yes, its own parent, not its own law.
I'm not quite sure that the merits are the same on this particular case if the non-conforming use itself has lapsed. And by your own admission, based on some of the questions that were asked, a business license hasn't been supplied. A occupancy permit on the first floor for the new use hasn't been supplied. In my eyes, based on the information that was submitted, we have an illegal use that shouldn't be operating in what now is legally a residential building, or should be a residential building.
No, I would disagree that it should be a residential building. It's been a commercial building from the beginning, and the regulations were changed to make it non-conforming. And there is precedent for the lapse case. The board has never made that distinction in any of those other cases. I know at least one of those precedents, maybe more of them, because one of them was before 2015, the E Street, the 1247 E Street case was decided well before 2016 change. So that was a lapse.
Mr. Sullivan, you could do this. It'd be great. I see where we're going with this. I do think it would be very helpful if you could help us find some precedent to support the argument that you're making, because from what I can see and looking at the precedents in front of me, I didn't see that. So if you can find that to support it, I would be very happy to.
Yeah, it's already in the record, and these cases have never been questioned since 2016, and the ANCs didn't question it. It was the first thing right off bat, like, yes, that makes perfect sense that this should be approved. And I've got the cases in the file. I certainly go into more detail on them to explain why they line up, but
yeah, as long as they're not summary orders, that'd be great. As long as they're not summary orders, that's great.
Difficulty and the exceptional condition stand regardless of whatever paperwork was or was not done in the background, because it deals with the physical aspects of the property. But I'm happy to go into more detail if you want. I could go into transcripts. The fact that there's a summary order doesn't mean it's not a precedent. It actually means it's an even safer, clearer precedent that wasn't questioned or needed to be discussed or has never been challenged by anybody. So, but I can, whatever the board needs as far as additional information, of course, we're happy to provide.
Well, I appreciate what you're saying. The logic behind it, I totally agree. I'm just trying to look at what we have in front of us from the regulations, and I do think you have a wonderful database, and you would be able to find precedents to support what you're saying.
Yes, it's all in there. Always supported by the Office of Planning as well, just as they have in this case as well. So I would refer to their analysis, and maybe you could ask them on that point, because I'm a little surprised by the, I guess by which way this is going, but
okay,
I could find more. It's like 6-0 since 2016, so I can bring up those 6 cases and go into great detail on those.
Okay, I appreciate that. So what we can do too, let's look at the special exception. If you've talked about the fact that you're not increasing the, this is a multi-use building, or it's what you have before us is a multi-use property. It's not a residential property. So can you just help me to understand how E5201 would apply to a multi-use property and not a residential property? Because this is not a purely residential property, although, as your architect pointed out, it's predominantly residential. It's not, it's a multi-use property. So I'm trying to understand, because typically you might think about it, as you know, the regulations allow 60% occupancy for residential up to 70%, but in other areas, it's only 40%. So if you could help me a little bit to understand how I should look at that, because then that suggests to me you need an area variance to increase that square footage on the lower level. if it's
I can
increasing
actually
the size?
speak to that briefly. So in the document you had pulled up earlier, that's the full package. There is on, I believe it's labeled as page 8, a letter. It's an email correspondence between myself and at the time the zoning administrator Matt LeGrand. He's obviously since retired, but in which we actually discussed that exact matter and the reason that it was allowed to be considered residential in terms of how we looked at the lot occupancy versus commercial is because of that determination that the residential space was the predominant use. So that is in the record. It's in the submission.
Okay, so we'll look at, so we're gonna follow up on that. If you can share that correspondence and we could follow up with that, that would be helpful. If you have a copy of that correspondence. Because that would seem to me that if that is the interpretation that the current zoning administrator has and that we would support, then that would be a way to approach it.
Right, and again, the document that we had up earlier that we were looking at the floor plans, it's in that same document. It's just on one of the earlier pages.
Very good. All right.
I'll find out exactly where it is, Chairman Blake, and let you know as we're going forward.
Okay. All right. Let's see. Mr. Smith, do you have any other questions? Vice Chair Miller, do you have any questions?
Thank you, Mr. Chairman. That was an interesting dialogue that each of you had with Mr. Sullivan. And I look forward to getting that additional material backing up the argument, because although those other cases may have been summary orders, if we get to an order in this case, it may not be a summary order and would need the rationale. So on the rear addition, you said that there are no windows on this side. Is that what you said? So that there shouldn't be an impact on privacy, I think is what you said.
Yes.
There are windows though on the rear, because we have testimony, I guess, in the record from the abutting properties on the rear saying that their privacy from the windows that look over their yard would be impacted.
So
how many windows are on the back, I guess?
I'll ask Brian how many windows are intended to be on the back, but I'll note that there's a 30-foot rear yard setback and that the letter from the Hasselmeyers, they're not adjacent, despite claiming to be adjacent. There's a property between them. So they're about 50 feet away from the addition, which has a 30-foot rear yard.
Okay, I appreciate that response. Do we have any, did you show renderings or elevations showing that rear?
We didn't for the rear, but in the plans that we pulled up earlier, we showed our kind of preliminary layout for windows there that we're showing 2 pairs of windows per floor that would be residentially sized. So effectively, we'd be adding 8 windows if you had those up, 4 per floor.
Okay. Okay, thank you very much for that response. Okay, I don't think I have any other questions at this point, Mr. Chairman, Mr. Vice Chair.
I have one last question for Mr. Sullivan. Mr. Sullivan, essentially what I see here too is your description of having 2 residential units, 2 principal dwelling units, flat, and a commercial space, essentially are 3 functional units of some sort. Now, I can't say the residential units, but 3 functional units. This is a zone that in order to get 3 functional units, or at least residential units, you would need to meet the 900 square foot rule. This is far from that. How is that plausible? And just help me understand that.
Sure, and we can submit that precedence as well. We have a determination letter also from Mr. LeGrand from years ago, explaining that with an existing non-conforming or non-compliant use, commercial use in the space that you could add a unit. And it would be limited to 2 residential dwelling units. And the
So we
commercial
should-
space wouldn't add to that.
So the commercial space wouldn't count. So you could have 3
Correct.
units in one building and it would not count.
Yes,
Okay.
because that only applies to the residential unit.
But in this case, it's a non-compliant.
I don't
commercial
think the
space.
distinction matters, but I mean, I can send you the letter.
Yeah, okay. And let me see. Okay, I'll have something for you to work with. Okay.
Did we find any additional clarification on? I'm assuming, Mr. Forehand, you were referencing Exhibit 20A. Did we have any additional clarification on this note from the former zoning administrator regarding this interpretation of the maximum lot occupancy? Because I share the same concerns that Mr. Blake shares regarding this. The applicability of Section 5201 to a building that's not completely residential.
So again, that's, I don't know if you still have it up, but the document that we were looking at previously when you were asking me about the floor plans.
The only thing I see on that within that set is on the title page that says relief is sought for the lot occupancy to allow 70% and a zoning analysis, but I don't see a letter from the zoning administrator.
I don't see it either. So we'll, it sounds like we're going to be filing some additional information. So we'll include that if I don't happen to find it.
Yeah, I don't know if there's a way for me to share this with you more quickly. I mean, I have it pulled up. Or I can, drop it in a box or email it to somebody, but.
If you can send it to staff, they can add it within the record.
Okay.
As a regulation explicitly states under 5201.1 for in addition to a principal residential building. And Mr. Sullivan, by your own admission, with some of this dialogue we've been having about the non-conforming, non-compliant use on the ground floor, is that this building, by your statement, was purpose-built as a mixed use or commercial building. So without that information, your statement contradicts itself.
Yeah, well, we have that clarification from the zoning administrator, both on that point and the 2 units plus commercial, so we can submit that.
Okay, thank you. I don't know if
Mr. Sullivan, also, I would ask if you could, I would focus on Bernstein versus DC BZA as one of the cases you might want to source to help me figure out why, because I understand that the linchpin for Mr. LeGrand's assertion was the fact that it was a continuing non-conforming. And in my mind, once that has lapsed, it ain't a continuing non-conforming. So that key component has gone. Now, so I want you to help me walk through that so I can get comfortable why that's not the case. And I think that might be a good starting point for that particular case. Okay. All right. So do we have any more questions for the applicant?
I don't have any more questions.
Okay. So we can, let's see, Mr. Blanchard.
Blanchard.
Do you have any questions for the applicant? Keep going. Mr. Blanchard, your face is not there and you may be on mute. I can't hear you.
There we go.
Okay.
So I think the board has asked a lot of good questions. And so I'm not going to ask an additional question at this time. If there are supplemental filings, I'd ask the opportunity to respond to those as well.
Let's see, Mr. Eckenweiler. I think you have, you can say something. Would you have a question for the applicant?
Good afternoon, Vice Chair Blake. And since I just came in late, my apologies. Mark Eckenweiler appearing on behalf of ANC 6C, which is an affected ANC in this case. You have our letter of support both as to the use variance and the special exception in the record at Exhibit 30. I don't propose to take up much of the board's time. I'll stand on that, but if you have
I was
specific
just actually,
questions.
you had a question for the applicant. I'm going to come back to you later for your statement.
Sorry, no questions at all for Mr. Sullivan.
All right, great. Thank you. Okay, so we're going to now move to the Office of Planning.
Good afternoon, board members. For the record, Shepard Beeman with the Office of Planning. OP's reviewed the application for the requested special exception and area variance relief from the use permissions and lot occupancy and finds that the request meets the criteria for subtitles E and X. Therefore, OP recommends approval and open for any questions.
Clearly from Mr. Beeman, from the foregoing discussion, there's a lot of questions. So I'm going to have to ask you to help me understand the same questions I asked Mr. Sullivan. For example, I want to understand why E5201 is appropriate for for the relief. And I'd also like to understand the impact of the non-compliance on the commercial space, and if that will have some bearing on the ability to apply what Mr. Sullivan cited from past zoning administrator LeGrand in terms of the ability to use that way. Okay, so you may not be able to do that right now, but I will need that from you if you're able to do that. Okay. Mr. Smith, do you have any questions for the office plan?
So I share that same concern that the Vice Chair Blake stated. I will also need some additional information about this question about the how the non-complying use applies in this case to the use variance, which seems to be, a topic of conversation today as well. If you could provide that as part of a supplemental report.
Mr. Sullivan, do you have any questions for the Office of Planning?
No, thank you.
Okay, Mr. Blanchard, do you have any questions for the Office of Planning? You're on mute.
I have two mute buttons. I just asked if OP, Mr. Beeman, would address the position taken last night by ANC 6C on the lot occupancy when he files any supplemental report. Thank you.
Okay. Any other questions for Mr. Miller? Vice Chairman, you don't have any questions for the Office of Planning?
No questions. Thank you.
Okay. All right. So now we could, any other agencies that we have to speak? No one else can speak on that. The ANC, actually, sure go, Mr. Eckenweiler, since 6A is not present.
Is this about, Mr. Vice Chair, is this about questions for OP? Because
no, we're done with OP now. We're moving on to ANC.
Okay, great. So just to recap what I said earlier, you have our letter of support both as to the variance, the use variance, and the special exception for lot occupancy in the record at Exhibit 30. I'm happy to stand on that, but of course, I'd be happy to answer questions as well.
Okay. Does anyone have any questions for Mr. Eckenweiler? Mr. Sullivan, Mr. Sullivan, I believe your client has a question.
Mr. Blake, Miss
I have a
Landry
question.
is
Miss
Mr.
Landry.
Yeah.
Oh, I'm sorry,
No.
I'm sorry. Mr. Blanchard, I apologize. You were sitting next to each other on my screen. Please go ahead,
Hi.
Mr. Okay, go ahead. Hi.
I'm Mary Landrew.
You
I
are-
own the property with my husband Frank, who I hope you all can see on the screen, Frank Snellings and Mary Landrew. We're so happy to talk with you all because you all are only the second group of people that have even allowed us to speak. So we really are grateful because Mr. Mark,
Miss
the
Landry, are you-
Mr. Mark, the ANC person from C6C that sent you a letter of support, never talked to us.
Miss-
And we live right across the street. So my question to Mark, Mr. Mark, who is the ANC 6C person, my question is, why didn't you talk to any of the neighbors that actually live next to this building across the street from your jurisdiction? It's not even your jurisdiction.
We're not under any obligation, and in fact, ma'am, under the rules, we could decide a case without even hearing from the applicant. We did in this case
Oh,
hear from the
okay.
applicant.
I'm not
and-
familiar with those rules. Yeah, I've just lived here 25 years. I'm sorry, I'm not an expert on the rules. I just want to ask you, you didn't think it was important to talk to anybody that lives next to this complete monstrosity? Will be a monstrosity?
In this instance, no, we did not.
Okay, thank you.
Thank you. And we're the party in opposition will have an opportunity to present their case shortly. Are there any questions further questions for Mr. Ekamala? Okay, I have one question for Mr. Sullivan while we're here. Mr. Sullivan, could you please explain to me what did transpire at 6B? You did allude to it in your presentation, but I didn't quite understand what happened there.
6B, last night they unanimously supported the use variance request on their consent agenda, and they voted 6-2 to oppose the special exception request.
What, do you have any color on the rationale behind it, or you would be unable to say it?
I do. They said that applicant seeks to renovate his property to occupy 70%. ANC 6B generally supports these variances, they misnamed that, because our neighborhood is zoned too restrictively for an inner city neighborhood. However, we feel obliged to reflect the sentiment of the neighborhood when there is sincere opposition to a particular project. The neighbors' enjoyment of their own backyards would be reduced by the presence of applicant's rear expansion.
Okay, thank you. And is that in the transcript?
That's in the record. That's in the record now. That was posted this morning.
Okay, I'll take a look at that. Thank you.
Exhibit 32, I think.
Does anyone else have any other questions before we turn to the party in opposition? Okay, Mr. Blanchard, it is your opportunity to present your position and to include all your witnesses and so forth. We have about 15 or so minutes, roughly, a little more than that, I guess, to talk to do that. So if you would proceed. Mr. Young, start the clock so we know where we are. Thanks.
Good afternoon. Good afternoon. I'm Lyle Blanchard, and I'm representing Frank Snellings and his wife, Mary Landrew. They are the property owners at 405 and 407 East Capitol Street, which is adjacent. I'm going to ask both of them to talk about their views on why the applicant has not met its burden on the standards for the special exception. I also have Mr. Jeffrey Levin as a witness, and he is the owner of 411, which is the adjoining property on the other side of 409. And I will now turn to them and let them speak.
Good morning, or afternoon, I guess, by now. And just a little history. My wife and I moved to DC in January of 1997, and 6 months later we bought a weed-infested and overgrown double-wide asphalt parking lot at 405/407 East Capitol, and we began the process of trying to build a home there to raise our children in. And we went through 2 years of planning and permitting, and then another 3 years of actual construction, and almost to the day, 5 years after we bought the lot, we moved in. And so we've enjoyed living there. We raised our 2 children there. They're now 33 and 28, so they've left the nest, so to speak. And so what we wanted to see is, when we looked at these plans that have been offered by the applicant, the property next to us will rise 29.5 feet above elevation. It will be right next to us. When people walk into our home, they'll look over and see this monstrosity if it ever is constructed. And they'll say, well, I thought you lived in a historic district. And my comment to them will be, well, yes, we once did, but we no longer do, because this thing has been allowed to be built there. And we are not opposed, gentlemen, to renovation and expansion of properties right there in our backyard. Fluor Corporation, which owns 403, they did an expansion several years ago, came to us, take a look, we said it's fine. We're not, no problem. Then our neighbor to the back of us, whose side yard abuts our backyard at 8 4th Street Southeast, they wanted to add 15 or so feet to the back of their property to add a bedroom. We said, fine, no problem. Go ahead and do it, and they did. Then 3 years ago, Mr. Gia came with a modest proposal and asked us to take a look at it. We looked at it. We said, no problem. Go right ahead. If you can get your approvals, go and do it. He got somewhere in the process, and at some point, wherever that is or was, he decided not to do it. And so our situation is that we are going to be looking at this, huge, development in a historic district. And I don't know if you all have the packet in front of you of the pictures that we submitted this morning, but if you do, I'd like to quickly run through those with you if I could. Do you all have those?
Can Mr. Young bring up the exhibits that were filed with?
Okay.
Yes, I do. Hold on. It's Exhibit 34. 3-4. And go beyond the next page, please.
All right, that is, if you look at that picture and you see the automobile on the left, and you can see a yellow flag up in the trees behind the brick wall, that flag stops at 14 feet above elevation. If you go up another 15.5 feet, you will clearly see that construction from 4th Street's sidewalk. Very clear. The property that's just shown briefly there on the right, that is number 8 A Street, and the property to its right is number 10, which they have lodged a complaint against. And so let's turn to the next page real quick, if we could.
Mr. Young, can you go to the next page, please?
And that's just the rear of the existing property, and then we can move to the next picture.
Next page.
And that's an enlarged view of the rear of the 409, and it also shows 411. It also shows the tree that is growing on 411. So we can go to the next picture.
Next page.
That 2 pieces of tape, that is was put there by Mr. Forehand, the applicant's architect, to show how far back on the lot the additional 10 feet would bring that structure that they would like to construct. And next picture, please. What the 60% versus 70% looks like, that's how far back it would go. Next picture, please. Next picture, please. No, but that's okay. You can go to that. Yeah, okay. And that again gives you the extent of the coverage or of the overage. And now you can see it taking shape. It's going to be a huge rectangular figure. And then if we can go to the next picture, please. That will show from our property how that thing is going to tower over our side yard, where we entertain a good bit. We almost live out there in the spring and summer and love being there, and we will have this monstrosity looming over us and right there adjacent to us. And then the final picture.
Next page. Yes, thank you.
That will show you that, and Mr. Levin will speak for himself, but Mr. Levin to his east has a much larger building next to him. And then if this addition is allowed to be constructed at 409, he will be basically operating in a canyon. And so that is the end of it on the pictures. And we would just simply urge the committee and the BZA to oppose this. And thank goodness, when we did get notice of a meeting, we went to the ANC 6B meeting, and they voted with their planning and a zoning committee in favor of this. And then also last night by a 6-2 vote, with the 9th member not being present. So that's.
Thank you, Mr. Snellings. When you say the P&Z voted in favor, you mean in favor of your position?
No, they voted in favor of opposing it, yeah.
Right, your position.
They opposed it.
To oppose. Yeah.
Yeah. All right, thank you. And now, Ms. Landrieu, would you testify?
Thank you so
please?
much. Yeah, I really appreciate my husband's presentation. He's worked so hard on this, and it's been so worrisome to us. And gentlemen, you have to forgive me. I don't know all the details and the rules, and I'm sorry I didn't have time to study up on all the details. But what Frank said is absolutely true. We love this neighborhood. We've raised our children here. We've been here 25 years. We have been as upstanding citizens as possible. We have love our neighbors. We've worked and cooperated with them. We actually loved the cleaners next door. It was a Capitol Hill valet. I brought my clothes there almost every day. We have no problem. When we built in this neighborhood, people said, "Are you all crazy? That's like a bad neighborhood, blah, 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 blah." We said, "Look, we love the city. We want to help rebuild the city." You can look at the picture of what was here and my husband basically designed and built this house. When people come to my home, we entertain all sorts of people here, neighborhood kids, people. We have Halloween. It's one of the favorite Halloween places on East Capitol. Everyone knows my house. And they come in and they say, "Geez, you did a great job renovating." We said, "We didn't renovate this house. We built this house from scratch." And people's just, their mouths drop open. They're like, "But it's looks just like it fits in the neighborhood." We said, "That's because we respect the neighborhood. We know where we live. We know the history of this neighborhood." And for this developer who doesn't even live here, come into this neighborhood and try to sneak this through, because when they came to talk to us 3 years ago, I said, "Frank," because it's a long story, but I'll get cut short. I said, Frank, you better talk to this gentleman. I have no problem in buying the property, but let's make sure whatever he's going to do with it. Oh no, don't worry. We're just going to renovate it. It's going to, it needs to be a little fixed up. We said, fine. It looks fine to us now, but if you want to fix it up, that's great. But he doesn't. He's asking for a 10-foot extension, which will severely damage our property, all the neighbors on our block. I don't care what Mr. Mark says, who's across the street, and he may be right. He doesn't need to talk to us, but out of courtesy, you would think he would. So we have about 12 neighbors that are the closest neighbors to this, from the front, the side, the back. We are all strongly opposed to it. And like Frank said, we want more residents. We want more commercial, if that's what you all want. We are not opposed to it. But this is a monstrosity that they want to put up. And I'm not even sure he wants to live there. If he did, I might say, well, whatever. But he wants to drop this in our neighborhood, I guess, to make a buck. I guess that's what people do these days. And this is in violation of so many things. They did not tell us all the notices. They went to the meetings. The first meeting we were able to go to was, I think, Frank, yesterday or the day before, because nobody bothered to come tell us about this 70, this extra 10 feet. So the final thing I'll say is I want Jeff to speak. Levin, he's new to this building he bought on the side, but his building will be even worse affected than ours. And I'd like Jeff to speak. And then Miss Kathleen, who I hope is on the call, she has a letter from about 8 or 9 neighbors that are outraged. We are outraged. This is not a little thing. So we ask you to kill it as best you can today. And if not, then we'll continue to work on this because it's just not right. And again, if he wants to go to his 60 feet, he's entitled to that. Now, I don't say one more thing. I don't know anything about the use, the conditional use. Trust me. It doesn't matter if you gentlemen decide you want to put a commercial space there. We're fine as long as it's not a bar or a marijuana smoking place. We have enough of those on Capitol Hill, but you all do your rules. If you want to put a residence there, perfect for us. We don't complain. What we're complaining about is an out of city neighbor to, come in and drop this monstrosity and wreck our block without really talking to us about what they want to do. And we're just very upset. So if Jeff could speak, that would be wonderful.
Thank you, Ms. Landrieu. Mr. Levin, can we hear from you, please? I see his name up on the panel, Jeffrey Levin.
Yes, Jeffrey Levine. I'm here.
Are you available for your video?
Jeff,
I'm in a car, so it's not nice.
So you only got 2 minutes, so hurry up.
Mr. Levin, we need your testimony.
Well, if Jeff can't speak, is Miss Kathleen on?
Cell towers.
Is Kathleen on?
No.
There he
Jeff
is.
is there.
There he is.
Jeff, please go ahead. You got 42 seconds. Jeff?
Oh.
Yeah, Mr. Levin, you can call in on the telephone if you like.
How do I do that?
You're going in and out.
You can call on the telephone. The number is 202-727-5471.
Yeah.
202-727-5471.
Can you hear me now?
Yes.
Okay. I got out of my car and I apologize.
Yes.
I think you have more than 42 seconds. I think we don't count technical difficulties as part of the 15 minutes or whatever it was.
Thank you, Mr. Miller.
So, guys, I appreciate the opportunity to see 411.
Mr. Levin. Mr. Levin, if you can hear me.
Yeah.
I don't want you to waste your time. I want you to try to communicate in this manner. try to give the phone number that Chairman Blake gave you a call. That way we can maximize your time because you're breaking up.
What is the phone number one more time? What is the phone number?
202-727-5471.
That any other thing I need to dial?
I believe so.
Okay, I'm calling right now. Thank you.
While we're waiting, can I just ask a question for the record? If you all have a concern about the 3 units, because right now it's like everything, business on the ground floor, apartment upstairs, and that's been perfect. We've had lovely neighbors for 25 years. I don't know why, if it's against the rules for them to put in 2 residences up top, which is a small building, and then still have a commercial. I don't know if that's a problem, but I might want to just put that on the record. I heard someone talk about that.
Ms. Landry, we would appreciate that. We are aware of that.
Okay, good, because I didn't realize that could be a problem as well.
We're still waiting here.
Well, maybe we could go to Miss Kathleen. Frank, is she on? She was so good last night. Is she on? Lyle?
Mary, we have to wait. We have to wait for the board to conclude the party status witnesses.
Oh, okay, okay.
Kathleen is a person in opposition, so we have to
Oh, I'm
wait
sorry.
for Chairman Blake to get to that portion of the hearing.
Okay, thank you.
You're welcome.
While we're waiting for Mr. Levin to connect, let me just say it's good to see you, Ms. Landrieu. We in the district miss your friendly voice and and advocacy on behalf of our citizens in the United States Senate. And wish you.
Thank you, Mr. Blake. Yeah, I thought maybe I might know some of you all because we worked so hard together with the city for so many years, and y'all are just doing. The city's doing so well.
I know you did. I know you did. I was in the council chairman's office
Thank you.
for 27 years and saw the fruits of
Thank
your
you.
labor.
And that's why this is so upsetting. I mean, it's not just me. I mean, it's not because I was a senator or that it's so disrespectful for this attorney that represents this gentleman to not talk to the neighbors. I mean, and they really didn't. And it's like a big surprise. And we're like completely caught off guard, and it's just hurtful. So anyway, I'm sure there's some rules they know how to get around, but again, the person that purchased this property, he purchased it for fair market value. I realize people have a right to make a profit, no problem. But I do have a problem with sneaking through something without talking to all of us and then telling you all it's no big deal when it really is a big deal. And if y'all want to come to the house, some of you might have already been here, you can see it with your own eyes, and then you'll really know what we're talking about. So I'm really sorry Jeff's disconnected, because our house, as you know, is 36 feet wide. So we have a little space, and we have, when our yard is pretty much open, but he is only 18 feet and he's on the other side. He'll be on the other side of 2 straight up walls.
This is a good discussion, but let's do this.
Here, guys.
Are you in?
I'm here.
Can you,
Oh.
I'm good, and if you all can hear me, I'll be brief and very direct with
Please
my,
proceed. Thank you.
okay.
Mr. Young, can you put 2 minutes on the clock?
Thank you, guys. So the proposed addition or monolith destroys the value of my property. It's a violation of my quiet use of the property because it's going to block me in. I saw the slides and the presentation, and I was at the ANC meeting yesterday, and I don't think the pictures did any justice to the damage to my property. The property to the east of me goes back even further. So if this addition, is permitted, my property value goes in half. And I also believe that I don't support it. It really would affect my property value and my enjoyment of the property. I think that it would be one thing if the owner of the property was looking to live in the property and live in the neighborhood and contribute to the neighborhood, but that's not the case here. And I might feel differently, but I wouldn't the way it's currently drawn because, my backyard, which as you all know is scarce in Capitol Hill and DC and Capitol Hill, is pretty much, worthless. I also believe that this, the extra 10%, and I'm not a zoning expert by any means, is okay if it doesn't harm other people, and if there's an intent to contribute to the neighborhood, not build something that I believe is out of character for the neighborhood. I oppose it 100% the way it currently is. And I'm open to, if you have any questions for me, I'm happy to answer.
Thank you very much. Does anyone have any questions for Sullivan? Okay, Mr. Blanch, I'm sorry. Back to you.
I'm sorry, Mr. Chairman Blake.
Yes.
Were you asking if any parties had questions? For Mr.
Yes, actually, yes, Mr. That's right. Let me finish this is their overall presentation. So let them finish it up and then you can ask, you can cross-examine. Sure.
Thank you.
Go ahead, Mr. Blanchard, you want to finish up?
Thank you. Yes. So just to wrap up, you've heard from both Mr. Snellings, his wife, Mary Landrew, and the adjacent neighbor or the abutting neighbor. So both of these two property owners are abutting. The property owner you hear from later is adjoining, even though she's one lot away. And their testimony that you've just heard shows that they are adversely affected by the additional 10% relief and this dense monolith. Even though there may be no windows, there is still some shadow. And so that, that affects them adversely. And as the architect of the Capitol noted in their exhibit, that testimony from the neighbors where there is impact on the adjacent neighbors needs to be taken into consideration. And because of that, I don't believe that Mr. Sullivan has met the test under 901.2B. Thank you.
Thank you. Does anyone from the board have any other questions for the party in opposition? Okay. Oh, yes, Mr. Vice Chairman. Go ahead.
Thank you, Vice Chair Blake. I think I know the position, but I'm not sure that they clearly stated it. You don't oppose the use variance to make the design office legal, I guess, if that's what they need, if that's the relief they need, or could you just clarify if you oppose the use variance for the,
Yes,
or
thank
Before,
you,
continuation.
Lyle, before I
Miller.
answer, can I answer?
Mary,
Okay,
I'm
Lyle, go
sorry.
ahead. You answer.
This is
Go ahead.
no, Mary. I know what you want to say. But
Okay.
Commissioner Miller, my clients do not oppose the use variance. The
Thank you.
only
That's all I wanted
issue
to
they're
know.
opposing, thank you.
That's all I wanted to know. Yeah.
Well, Lyle, that's exactly what I was going to say. Like, I want y'all to know, we love the cleaners there. We like the interior design people. They were so lovely. We love the ladies that were there. We never wanted them to leave. They were the loveliest people in the world. We love having their office. That's not the problem. The problem is what he's trying to build.
Okay. All right. Thank you very much for your testimony. Now we're going to open the floor up to any further questions. Mr. Smith, anything? Any other questions from you? Okay, Mr. Sullivan, you have the opportunity for cross-examination of the party in opposition.
I think I'd like to briefly ask a question of Mr. Levine, if he's still on.
I'm here, Marty.
So you mentioned that it's important that the applicant live at the property. Do you live at 411?
No, I don't.
And you said that your property is going to dip in half. Do you have an appraisal showing that your investment property would lose half its value?
I've been in the Washington area for doing real estate for 30 plus years, as you know. No one can predict what the value of a property is. So my speculation, if it's worth whatever it's worth, what is being proposed, the property value, if I wanted to sell it, would be at 50% discount to something that would be more palatable for the neighborhood.
Yeah, thank you. I have no further questions.
Okay, thank you. All right. Let's see. I think we've been. Let's see. Is Mr. Eckenweiler still online? I assume not. So, Mr. Young, is there anyone who wishes to testify? We should have at least 2 or 3.
I believe we just have one signed up. She's calling in by phone.
Okay. Is she here now or not?
Yes, I just brought her in.
Okay. Okay, great. And it is who?
Kathleen O'Reilly.
Okay.
I'm here.
All right, Ms. O'Reilly. Thank you for joining us today. You, as a member of the public, you have 3 minutes to provide us with testimony. Please state your name and address before you begin. Your 3 minutes start now. So whatever you like.
All right. Can you hear me?
Yes, we can. Please state your name and address before you begin.
So there's a lot of feedback in the
Remember to turn
background.
the background noise off.
Can you hear me?
We can hear you, but I think there's some background noise from YouTube or something.
Let's see if this works.
Can you go into a different room or something?
Let's see if this works. I don't know if it'll change. Just a second, I will move.
Can you go into a different room or something?
Let's see if this works. I don't know. All right, I'm in a different location. Is this better?
Yes. Go ahead. Thank you.
All right. All right. All right, I'm going to start. My name is Kathleen O'Reilly, and I both own and live at 414 A Street Southeast. and I'm opposed to the application. And hopefully my pre-hearing submission makes clear that we neighbors are not against small business on East Capitol. Quite the opposite. Those small businesses that are here now add convenience and a wonderful layer to the social fabric of our neighborhood, as did Monica at the dry cleaners. I live on 8th Street, 1 block over from the block at issue, and I'm closer to 5th and 4th. And from my 3rd floor back bedroom, with leaves still on the trees, my view of what would be this eyesore extension is not affected. But once the leaves fall, I suspect it would be. I received no notice from the applicant and do not know what notice he provided, to whom, when, in what format, and with what parameters he applied as to neighbors. Following the hearing, I will submit a petition opposed to this application by 8 additional neighbors, as was given to me early last evening. I wish to comment on more than my limited view, as obviously not the one most important here. The applicant's representative at the ANC committee hearings made clear he thinks his client has a flood today. Basically, that you will look at the shadow study measurement, consider the effect on view as slight, vote approval, and just move on. That in effect, what we opponents say today will be a waste of time. I certainly hope not. View is an important factor in any common sense understanding of the legal standard required to be applied, namely the use and enjoyment of one's property. And the burden of proof is on the applicant, not on us opponents. In the case of this application, it's critical to consider view in context. The applicant, as we've learned, is a realtor in Maryland who apparently has never lived in DC and apparently does not intend to live on this property. The degree to which the view of a homeowner in this neighborhood might be reduced by such special exception may seem insignificant, slight, or even silly for anyone living on a much larger piece of property in the suburbs, for example. But this is a dense neighborhood where the views we have are, under the best of circumstances, extremely limited and thus all the more in need of protection. Also relevant is how the requested extension goes across the street from the property, and likewise as would be seen from 4th Street when we neighbors walk by that driveway that's next to the Marquette University dormitory. So this is not exactly landlocked as was described. It seems clear that the applicant realtor bought this property a few years ago, knowing the space limitations and the criteria for any exception. His original plan came within the 60% expansion limit, but he since changed his mind and decided he can't get as much profit from this investment as originally assumed, so he wants to squeeze out more profit by building this expansion. And the word lapse is now, I think, relevant based on the recent discussion a few minutes ago. Namely, it appears that when he bought this property, he was unaware of or took no action when he apparently had a lapsed business and a lapsed residential permit. And when I and my husband bought this home from another part of the hill, we both made sure that there was a current certificate of occupancy for the basement apartment in this home. Both my late husband and I, at a point years ago when we were going to be doing business out of our homes as architects and lawyers, we made sure we had our business licenses in place. Frankly, a little bit out of fear of getting in trouble, but also out of respect for this neighborhood and what those rules mean. And so in all due respect, I really don't think it's the role of this commission, or this body, to try and bail this applicant out of what was a bad business plan. And I hope that you will see from my pre-hearing submission a little of the history of this little piece of Capitol Hill we all love and consider ourselves to be custodians, and where even the American Historical Association chose to place its national office, which is down at my corner, 1 street over from the property at issue. So I thank you for listening, and I thank you for your service to our community.
Thank you, Ms. Riley. Now you're going to send us a copy of a petition this evening.
I am.
And we will
I
review.
will as soon as the call is over.
Okay, make sure we get that, and then we'll review your statement as well. Thank you very much for your testimony. Does anyone have any questions for Ms. Riley? Okay, so I thank you very much for your time. Okay, let's see, where are we now? Okay, Mr. Sullivan, do you have any questions of anybody? Because it's gonna be time for your rebuttal.
No, I have no questions before rebuttal.
Okay, well, let's begin with your rebuttal then.
Thank you. So no matter how many times the word monstrosity or monolith is used, it doesn't get to the heart of the issue, the special exception criteria. When you don't have an argument, you use passion, hyperbole, stories, and I think it'd be very helpful for the board to look at the fact that we've had no response to our shadow study from the opposition. They haven't even attempted to respond to it because they couldn't. It clearly is a shadow study that shows minimal impact, certainly not undue. Even from opponents' counsel, you haven't heard a response to that. Regarding privacy, we know there's no windows. We know the roof deck is near the front of the building, so privacy can't possibly be an issue. Character scale and pattern. This is supported by, in addition to CHRS, HPRB, there's no view of this from East Capitol Street, and it's not out of line. It doesn't protrude past buildings, even the building that's adjacent to it. And on each side, it's bookended by buildings that go significantly longer than that. So there's definitely not any impact from character scale and pattern. A couple things I'd like to point out too in this is that the highest point of sloping roof is 5.5 feet less than the max height. The rear yard's 30 feet, 10 feet more than the minimum required. An OP report called this out specifically, noting that there is, quote, minimal increase in shadow coverage on the adjacent properties. And also noting that the rear yard requirement was exceeded and the height is well under the limit. We're not asking for 10-foot rule relief. I take some issue with, and I don't think it's appropriate, that opponents feel like they can deceive or exaggerate or demean the applicant who they don't even know, as if there's some failure of integrity because he's seeking a special exception, just like many other people have done. Saying that this is tried to be sneaked through is just a falsehood. We've been to 5 ANC meetings, and Mr. Snellings was at an ANC meeting in July that he chose not to speak at. And then there was a meeting last week. So to say he found out about it last night at an ANC meeting is just a falsehood. Mr. Levine told the ANC last night that he lives at 411 for some reason. We hear today he doesn't. He disparages Mr. Gia for not wanting to live in the building, even though he's in the same business Mr. Gia is in. For some reason, it's important that Mr. Gia has a real estate license in Maryland that he doesn't even use. These are not relevant facts. It's not relevant testimony. So I would just point out that nothing you've heard in response to this has addressed the 3 items that matter here, aside from the procedural issues that, of course, the board has talked about, and I assume we're going to submit additional information for. But the shadow study clearly shows no undue impact. The privacy, that's clear. There's no impact on privacy. And the additional 10 feet being requested is not out of character, scale, and pattern. Can't even be viewed from the street. It's landlocked, so it's not viewed from the alley as well. And that's all I have. Thank you.
Okay, thank you. Thank you, Mr. Sullivan. Now, we're going to do something a little bit the same but different. We're going to practice the Hill Doctrine, which is we're going to allow having closing statements from both the party in opposition, and then finally the applicant will have the last word. So, Mr. Blanchard, if you'd like to make a very brief closing statement, I'd appreciate it. And then Mr. Sullivan will make his closing statement. We are going to have a continued hearing, and we will review at the end of these two statements the additional documentation that the board would like to see. So let's go through that statement, Mr. Blanchard.
Thank you, Vice Chairman Blake. This addition, even though it doesn't have windows facing the adjacent property, it does have windows, you heard from Mr. Forehand, that face properties on A Street, their rear yards, and those have an adverse impact on their privacy. The structure, the plans aren't very fulsome, as the board noted at the beginning. So there's not a lot of detail for us to respond to. The shadow studies show some impact, and there is impact on that basis, whether Mr. Sullivan wants to characterize it as minimal or not. There is impact on both the adjacent properties. And the scale is just, without detail, oppressive. My client did not have notice of Capitol Hill Restoration Society's meeting, did not have notice of HPRB's meeting. I know that's outside of your jurisdiction, but no notice was given there, and we plan to appeal that conceptual approval at HPRB because there is, this will be visible, as you heard in Mr. Snelling's testimony when you saw those photographs. You could see a yellow flag above the car, and that shows it's visible from 4th Street. That is a private alley. There's no structure there now, but it's visible from 4th Street. And that's the same issue we'll bring up with HPRB. The fact that it's not visible from East Capitol, we understand, and we're not disputing that. But it is visible from 4th Street and will affect Ms. O'Reilly's view shed, the neighbors along them, and the two adjoining property owners. So we're not trying to demean the applicant. We are trying to get appropriate information from him to assuage my client's concerns about the impact, the adverse impacts on privacy, view, light and air, and those are issues that the board has to take into consideration. Thank you.
Thank you, Mr. Blanchard. Mr. Sullivan, with the last word. Are you here?
I am. Thank you, Mr. Chairman. Video coming on in a second. Thank you. I'll be brief because I understand if there's going to be a continued hearing, we'll be talking again and submitting information. The shadow study has some impact. We don't dispute that, but that's not the standard. If the board were to find that small amount of impact was undue, I think it would be a first for that level of small amount of impact. Regarding windows at the rear of a house, it's a 30-foot rear yard again, and I don't think the board has ever considered a 30-foot rear yard in a 20-foot rear yard zone having windows on the back to be a privacy issue for anybody in an urban neighborhood row house district. Regarding character, scale, and pattern, you've seen plans that show this bookended by much larger buildings. It certainly doesn't extend beyond them, and it can't be seen from the front street. So on the three relevant areas of the special exception criteria, I think it safely meets all those requirements. And I don't actually think that given a responsive response to any of that. Regarding the use variance, I assume we'll delve into that more with additional submissions, but this is a case very much like other cases, whether they were lapsed uses or not. And I don't think that how it got to where it is actually a critical element of the use variance analysis in this case, because it relates to the property and the condition of the building and what it would take it to residential physically, not a lack of paperwork. For that reason, I think, and again, that's supported by everybody as well. So that's all I have on the entire application. So thank you.
Okay, thank you very much, Mr. Sullivan. Okay, Mr. Smith, I know you've been taking copious notes as to what you want to have for our continued hearing. Do you have a few things you want to put out there?
Well, I just need additional clarification on if you can provide some information about a business license. I think, Mr. Blake, you spoke to that. If there was a business license for the existing business as there now. If your applicant has a rent roll that shows that it's been it has been leased or something of that particular nature continuously. I think that's all that I need some additional information about clarification on the use of E5201. I think we beat that one to death. And the other information I need is from the Office of Planning, which I think they're aware of. That's all I need, Chairman Blake.
Okay, so additionally, I'd like to have, you did the input on the precedents, as we talked about for the lapse, the impact of that. If you want to comment on Bernstein versus BZA, I appreciate that. Also, if you could get a little bit more information about, let's see, my handwriting so bad I can't read it.
While you're looking for that, I have one more bit of information that I would need. That letter that you speak of from the previous zoning administrator, I recommend,
oh yes, that's it.
if you can find that particular letter, but also follow up with the current zoning administrator as well.
And the other, yeah, thank you. That was the point I was looking for, LeGrand. If you can find those two emails that you said you had. And don't forget, the business license is not just the business license. It could be the business. I like to see both because there's a tie between that. And also, if you can have some more refined, not necessarily refined plans, but a lot of things that we talked about that would lead to the privacy, et cetera. It's kind of like you're saying it, but we don't see it. And because we can't see it, we can't say it's true. And it wouldn't be reflected. We want to have the plan reflected in what we actually approve. And as there's a critical issue with privacy and so forth, we probably want to make sure we have those windows exactly where we think they're going to be, if nothing else. Ms. Vice Chair Miller. Vice Chair Miller. Vice Chair Miller, did you have a comment? I think he did.
Well, can I expand on what you just stated? Because this is going full circle to a comment that I had made earlier in this in the hearing. Not only would I recommend that you put in the windows, because these are the concerns that was raised by Ms. Landrew and Mr. Snellings about privacy. So, given everything that was heard, I would recommend that you just provide some type of floor plans that would show what corresponding rooms these windows would be associated with. So if you could put put together, revise these plans where you can show the rooms. That would be probably more beneficial to you at this point in time.
Mr. Vice Chair? Can you hear me?
Okay, is that all we have? I'm trying to see if,
Can you hear me?
yes, fine. Yes, sir. Go ahead.
I'm sorry, I'm having connectivity issues. If I appreciate all the information that's been asked for. It's a lot of information. I appreciate Mr. Sullivan's agreement to provide that information to us. I don't think we have in the record, correct me if I'm wrong, the Historic Preservation Office report or the Capitol Hill Restoration Society written comment, if there is one. Is that in the record, Mr. Sullivan, already?
Commissioner Miller, the CHRS didn't weigh in at all on the zoning issue. My understanding is that they weighed in to HPRB on the historic issue. So, sorry if I confused that, but I'll try to get whatever we have from them.
Yeah, so the HPO staff report, I think, would be helpful, following up just on Board Member Smith's comment about being able to see, hopefully there are more renderings there or perspectives from the adjacent properties. So I look forward to seeing all that information as well. Thank you.
Thank you.
Thank you. Okay, Mr. Sullivan, how long will it take you to gather all of this?
A little bit of time. We're not in a terrible hurry. I know we have some plans, and I would defer to Mr. Forehand on that, but also in getting input from the zoning administrator, I think that's probably the thing that's going to maybe take the most time, maybe 6 weeks.
Okay. 6 weeks. Okay, Madam Secretary.
No. Mr. Blake, can I ask technical question? Just one technical question. Could somebody give to us the information about how the Historical Society could render any opinion on anything of any structure that's not even designed? Because we haven't seen any designs. I thought that's what their job was.
Okay, I cannot speak to that
Okay.
at this point, so I do not know the answer to that question.
Okay.
Okay. Madam Secretary, what date do we have available? What do we have 6 weeks out plus minus what will be available for this for continued hearing?
So at this point, I think the November 5th hearing might be the best based on the board's schedule. It's either that or the October 22nd, but I think that might be too soon.
Okay, so we'll go with the night, what you said, 5th of November?
5th.
Does that work for you, Mr. Sullivan?
I think we could do the 22nd as
We can't do the 22nd. We're out of the country. It has to be November sometime, please.
That's fine with us. November 5th is fine.
Okay, so it'll be a continue here for November 5th. The record is going to be closed for everything that other than what we asked for and comments back from the respective parties on these files. So do you have the time frame for submissions?
So, I mean, based on, what the applicant said, perhaps they could submit by October 22nd and responses due the following week on October 29th, and then back for a hearing on November 5th.
Does that work for everyone?
Yes, it does. Works for.
Okay.
Yes.
Okay, Mr. Beeman, we also would like that information from you as well, that Board Member Smith requested.
Okay, that works.
Okay, thank you very much. Okay, so I guess we will adjourn this session of the meeting. I believe that's right. And I'll see you guys back on November 5th. the continuation of this hearing. Thank you.
Thank you.
Thank you.
Thank you.
Just to clarify, Vice Chair, so this is a continued hearing, so
Yes.
the record will be open, but it'll be, I guess, limited to what, or your
But we
hearing
just
will be
asked
limited
for,
to-
and the responses relative to this. There's one other piece of information that's available. The lady, Ms. O'Reilly said she was going to submit one additional document with a petitioning. Everything else should only be these documents and then the responses that would come as a result of these from the parties in the case.
Right.
Okay. All right. Do we have anything else to cover today?
No, nothing else from the staff.
This meeting is adjourned. Good night. Thanks, everybody.